Okay, the licensing committee has some unusual and interesting items on the agenda this time, um, and I think some if not most of them we just need to kick around the table and see how everybody feels about them. The first two, before I go into the first two, just in general, if you remember, we decided that when the exam, when there were some changes made to the CPA exam, and there was going to be a delay in the timing of the receipt of the scores last time, we decided to allow additional time for persons who lost credit but didn't realize they were going to lose it until it was almost too late to register for the next taking. Um, so we gave one additional testing window. We gave a window for those who lost credit. So I think what's happening is um, that was a pretty trying to think of the right word. It was what we decided to do was pretty standard. I mean, we said we would allow one additional testing window for those that fell into that class. But what's happening now is people who had little unique situations that were similar to that, but not necessarily exactly the same, are asking for additional windows also. So, for example, if you look at the first one under the name of coffee, this individual received a 74, which Kevin and I were talking a while ago. I didn't realize they gave 74s now. When we were taking the exam, it was 69 or 75, and there was nothing in between. But anyway, he got a 74, and he goes on to say that he lost credit for reg on 4/30/17 due to the failure also, and if the typical score release dates had been in place, I could have sat in early July for reg and potentially FAR at the end of August. Now the key there is could have, but he didn't. Uh, so he goes on to ask if we had an extra point in our pocket that we could give him, but um, his situation is that he's asking for additional time, 6 month extension ending 2/28/18 instead of 3 months and 10 days through December. So let's go to the next one then and talk about both of them together, and then we'll kind of kick it around. The second one uh, is similar but not, in that Anya Schindler, uh, she reached out to the board in July to get an extension on reg that was set to expire, and received this response that because she didn't test in Q2, she didn't qualify for the extension. So her case is she's asking for the same extension that we gave people who took it in quarter two, uh, but she didn't test in quarter two, but she's asking to be given that same thing. So the response that the board gave to her at that time was it was intended only for candidates who did, um, because of the delay in score returns, lost credit, who had taken the exam in Q2. So I think it would be wise if we just talked in general about what our intention is here, because I'm afraid, this is my personal opinion, but I'm afraid that if we start opening the window to little unique situations like this, that the window is going to be raised big and wide, and we're going to be overrun with unique situations. So I think it would be wise for us just to, everybody give their opinion on how do you fit, do we want to hold this rule to just what we said, this extension, and only allow extensions for those who were harmed by taking the exam in that particular quarter and not getting their score back in time to prepare and register and take the exam again if they had knowledge of what their score was. Um, so, Wendy, you want to talk
Um,
about? You want to?
well, first, I'd just like to confirm what members of this committee are here for the public. If we could just do a quick roll call of the folks that are on this committee, that would be great. Um, Larry Elmore, Andy Bonner, Pamela Church, Here, Stephen Eldridge.
Here.
And Judy Weatherby.
Here.
All right, we have a quorum to make decisions. Thanks.
So I guess my question is, do we want to strictly enforce the window that we opened and go just by what we said, or do we want to address each one of them individually on its own merits? So,
I have a question. I just want to make sure I'm understanding the situation, given that I'm not as familiar with all those rules as you guys are. So, if I'm understanding what these two CPA candidates are asking, basically they didn't know in time to know if they needed to take another section of the test again. Is that accurate, or?
that's the general reason why we gave the extension, because when the exam went through massive renovation and it was learned that the scores from that particular quarter were not going to be received in time for those persons who got a failing score to register and take it again.
Yeah.
Then we gave them a window through December 31, I believe it is, 17, so that they would not lose that credit that they had from other parts and so forth. So,
and these people, are they not going to have an opportunity to take that test before then, or?
These two here?
Yes.
Well, Coffee,
He's one that, but beyond that date.
he could have taken the exam in July.
But he didn't know in time, right? Or he did know in time.
He says he lost credit for reg on 4/30/17 due to the failure. Also, if the typical score release had been in place, I could have sat in early July for reg and potentially sat for FAR at the end of August. But he didn't.
Because he didn't know whether or not he passed.
Yes, in his situation, though, he was part of the pool that received the first extension.
Okay.
But the way it is now, he's going to have to take two sections within one window before the end of the year, and he wants additional time. He believes that he should have another window because he didn't know through the third window whether he had passed or not passed in that second window. So he's already received one window extension, and he would like another on BEC.
It's just because he made a 74, not a 75.
Yes.
That's why he was asking us. He said, if you have an extra point in your pocket,
just give him a pass on it.
Wendy, let me ask you a question.
Right?
Stephen,
Sure, go ahead, Stephen.
you're more familiar with the day-to-day on this. I mean, with that rule change, I mean, and we granted that extension to accommodate for that issue. I mean, is there anything that we haven't done to accommodate appropriately for that change for that date issue, I guess you'd say?
I think with Mr. Coffee, yes, he has the last window to continue to sit. So he still has a window. We gave him a one window extension, and based on his scoring, he's going to have to take two parts during that window. But he does have an opportunity.
Yeah, his complaint is he's going to have to take two.
But I mean, a lot of people take the whole thing. I mean, okay.
Yeah, I mean, my point of asking is, I mean, I've learned this from Casey to be, being more compassionate, and I don't want to do something that's unfair to people, but also we've got to be consistent with how we handle this going forward, and I think we've accommodated for that gap, and I think if we grant, I hate to say this, but if we granted his request, I think we're giving him a something that other candidates wouldn't have. I mean, it's just we're granting another free window that we've already accommodated for that for the issue that we had for that, was it quarter two?
Correct.
And that's my concern. I mean, I think we've accommodated for that, and that's where I'm hung up with granting any kind of additional extension. Because, I mean, I think if, then we get into, well, you did this for him, why can't you give me an additional window because, I didn't pass and, and I lost credit. I mean, that's just my opinion. I'm not trying to take away somebody's success, but, I mean, those are the rules.
Hey, did you have something?
No, I'm good.
Do we need a motion of any kind, or are we?
Well, yeah, I think we need to decide what we're going to motion for to do tomorrow at the board meeting, but I just wanted a general discussion before we talked about them specifically, because if you open that window for one, you're opening the window for a lot more to follow that. Now, I understand there may be some really, really unique situations that we'll have to address, but this one seems pretty.
He does have an opportunity to, he has an opportunity to test and make it, and he did so well. He almost, he should do. Hopefully, he's basically got that one part under his belt. If he
Almost
just
asking for additional time just in case.
Yeah, that
he doesn't take the two and pass them.
Yeah.
Right.
But if he made a 74 before, and then he does as well as he did before in a little bit, he's going to pass that one, and hopefully he'll pass the other one. We hope he does.
So I would.
So what happens if he doesn't pass? He has to take two parts coming up, and if he doesn't pass these two parts, then does he lose all his previous credits on the other parts?
One of those that he's taking over is one that he's failed on by making 74. Carrying forward, lost credit for reg on 43017 due to the failure also. Lost two. If he doesn't pass both of those in the next sitting,
Like he's got two parts that are passed, that are one being 1029-16, which was audit, and it looks like he passed. Am I on the right? No, I'm sorry, I'm under Sonia. I'm on the wrong one.
He's lost 3 credits so far.
He's lost credit for 3 parts.
Mm-hmm. He's been testing since 2012, and he's lost credit for reg, audit, and reg again. I guess time limit is what it looked like to me.
and he's at the present time the extension runs through December 17. He's asking for further time through 2/28/18.
But am I reading this correctly? He has not lost any credit. It's just more of I need an extension in case I don't pass in December or on my next and last go round.
He would have lost credit for BEC, but we gave a one window extension.
Right.
And if he doesn't pass BEC in the last window, then he will lose it plus the other 2 that he's already lost.
So he has not lost any credits yet. He would only lose credit. I know he lost the one in April, but he has not lost any. And if he passes the 2 when he takes them in, whatever he's taking them, then the ones that are upcoming, then he would not lose any credit and he'd be done, right?
Correct.
But if he doesn't pass, then
there are lots of people who get into similar situations, and it seems to me that the only thing we should discuss is whether the delayed grading impacted him. Otherwise, it's heartbreaking when someone has to lose parts, but he's in the same boat as everyone else. And I
agree.
I don't think we should make a one-person exception.
is that what he's saying, that the delayed grading?
He said because of the change in the
given the
CPA
extension.
exam. That's what I'm saying.
We gave him the extension. So he's already gotten one.
We're going to start taking up individual cases.
My point
We'll
in
have
general, let's decide: do we want to consider individual cases or not. Now, I think we should read and consider any individual case, but at the same time, I think it needs to be very unique before we.
Really extenuating.
Yeah.
Yeah, I think the fact that we would be giving extension in the event that he didn't pass, I mean, that's where I have an issue with this. So, I mean, I would make a motion that we deny this request based on we've already given an extension, which saved him on that one part, but deny the request.
I second that motion.
Okay, we have a motion and a second. All those in favor, aye. Aye.
Aye.
Any opposed?
I think we're going to need to do a roll call since
Okay.
Stephen's
Yeah,
on the
Stephen,
phone.
Yeah.
Karen, do you have the names to?
Larry Elmore,
Aye.
Andy Bonner,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Judy Weatherby.
Okay, the second one is similar but different. The second one is pretty cut and dried. The situation here is the problem is created because she didn't take the exam in the second quarter, and so the extension that we gave was intended to only benefit those who took the exam in the second quarter. So there again, it's a unique situation only in that she didn't fall into that group. Our reply to her when she sent this letter in was the extension was intended only for candidates who because of the delay in the score returns lost credit. Since you didn't take it in quarter two, then it doesn't apply to you. So here again, unique but not really unique. There were a lot of people who didn't take the exam in the second quarter, but she's saying that because she didn't take it, she doesn't get the extra credit, extra time that we granted.
That extension was for grading. I mean, I think this was her choice to skip a window. She's no worse off than if she had taken it.
If there had been some reason that she had tried to take the exam in the second quarter and something happened to keep her from doing it, or if she didn't get her application in time and she missed the deadline by 2 days or something, but none of that, if any of that was true, it wasn't mentioned.
It wasn't a bonus we were giving people. It was making up for a delay that was not their fault.
Making up for a harm that they had incurred because of the grading delay, and she didn't experience that harm. So
I'll make a motion
that we deny her request.
that we deny her request.
I'll second.
Roll call.
Larry Elmore,
Aye.
Andy Bonner,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Judy Weatherby.
Aye.
Okay, moving on. We have an individual who submitted a firm name to be Lane, was it Lane CPA firm? Her name is Abigail Elaine Jackson. She submitted a name request for just Lane, and so upon being asked why she didn't use Jackson, which was her last name, she explained it was too close to, I guess, Jackson Hewitt or Jackson Tax. And it wasn't located in Jackson, Stephen, so it didn't apply to the location Jackson. So she is giving a response here as to why she wants to use Lane, because people called her Abby Lane. So,
And also, she mentioned that apparently she's unmarried, and when she marries, her last name may change as well.
Yeah.
So she wants to keep it something she can remain
She says,
consistent. This seemed like a reasonable request to me.
I've chosen a name that clearly ties to me as an individual as well as to my professional qualifications. So, to me, it's an adequate
Yeah.
explanation as to why she's using that name, and I don't know of any reason why we wouldn't approve.
I make the
I
motion.
agree. I think it also falls within the fictitious name rules review that we've got together on the little. It doesn't qualify as misleading according to all those criteria.
Right. Okay. Did you make a motion?
I did.
Okay.
I did make that motion.
I'll second it.
Roll call vote.
Larry Elmore,
Aye.
Jack Bonner, Andy Bonner,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Judy Weatherby,
Aye.
Is Jack Bonner considered a fictitious name?
Okay, moving right along. Wendy, you may have to help us with this one because since I've been on the board, we've not had an application from someone who had a felony, I don't think.
Okay.
So this next item deals with an applicant who I believe he is already an applicant in other states and wants to get a reciprocal license here. Isn't that right?
Correct. She is licensed in 2 other states, South Carolina and Alabama. She's applied for a reciprocal license here, and this board affords licenses to folks that meet the education, exam requirements, experience requirements, but also that have good moral character, which we defined as a lack of felonious activity. So if someone has a felony, it is in our policies that we bring this information to the board for your decision.
I'll just read the statute real quick.
Good.
The certificate of certified public accountant shall be granted to persons of good moral character who meet the education, experience, and examination requirements of subsections B through G and who make application for the certificate pursuant to 62-1-107 and under Tennessee Code annotated 62-1-106B. Good moral character for purposes of this section means lack of a history of dishonest or felonious acts.
So with respect to that, I asked her to provide more information on her felony conviction, which is what she provided. She provided court documents as well as basically a statement as to when this occurred, the circumstances behind it, and what she's doing now.
I believe she resides in Tennessee now, so that
Which is why she's
yes.
I'm not sure she technically needs a reciprocal license here because she's working for a firm
Georgia.
in Georgia, but it's always good. And she has applied, so
Because we got state-specific ethics.
yeah.
I read through that very carefully, actually a couple of times, and looked online, to kind of see kind of where she's working and what she's doing and that sort of thing. My comments on it, just to kind of kick it off, she says that she's going to approach the DA in the Tuscaloosa DA, and to try to get this removed from her record as a youthful offender. And after I read it and thought about it a good bit, I thought, I don't know if this is possible, but would it be possible to tie our decision to the DA's decision? Because that DA is going to have a whole lot more information than we have with regard to this case. We have what she provided, whereas the DA may know more of the surrounding circumstances in this case. I don't know. A felony is a pretty big deal.
Do we know that what Alabama and South Carolina, I presume they have the similar language that we have in our statutes, right?
I know I did not look, or I asked her to explain, and she did not include that in her statement as to any process she had to go through with them, and she didn't include that. But I did not reach out separately to those states. But states do have different language, so it's highly likely that they have defined good moral character slightly different than we have.
What's been our history on this?
Let me offer up some comments here, because I know most of you probably were not on the board. when this happened. I know we had a young man similar in age that was a student, I think, at the University of Tennessee in Knoxville that um, uh, had a felony conviction. It was to do with, as I remember, drug related. He actually was caught with a firearm deemed to be in his possession. He wasn't carrying it, I don't think. It was just on premises in his apartment when they did it. But it was a situation where he'd gone to school. He just wasn't ready. He was doing all the wrong things. And from that time, he had gone back to school. I mean, he served his time. I mean, he actually served time behind bars. I mean, for 3 or 4 years, and then went back to school, went back to his community. His mother was a CPA. He had gotten married, got very involved in his church. I mean, he had a character witness here. I mean, the fact that he had a felony conviction did not keep us from granting him, permissions to be licensed. It's a matter of, he was young, he did things wrong, he served his sentence, his time. He had demonstrated through his actions a total turnaround in his character, and so that's just one instance that we've dealt with before, Judy. I mean, this one to me is even less severe than that because I mean it was a matter of she passed some bad checks, and now she had paid all of those back. I mean, she did everything that to make the harmed parties whole, and she was very young, and now she's, um, totally turned things around and made a commitment to have the right kind of life and reputation and represent the profession in the right way, I guess is what I'm saying. So we have done this before. It has come up. That's the last time I remember, but I sit here and almost cried hearing that young man's story because you can just see yourself in that situation, very young, being influenced by peers and getting off track and
One bad decision.
yeah, one bad decision. And so, but this one is not nearly as severe as that one, I don't think. But I just offer that as background from.
My question, I guess I just didn't realize that writing bad checks was a felony. That just threw me off. Is that a felony?
Is in Tennessee as well.
Oh, okay. Wow. I mean, people do it all the time. I mean, it's just.
When you were reading the statute a while ago, the law, did it say that their history had to be free of felonious?
Under our Tennessee statute, we have good moral character defined as lack of a history of dishonest or felonious acts.
I'm kind of, my thoughts on this happened 13 to 14 years ago, and this person's done what the courts has asked them to do. They haven't committed any kind of issues since that time, at least that I'm aware of, according to what we have in front of us. I just personally find it hard not to say, look, you may, if I was held responsible for things I've done in the past, I mean, we've all made mistakes, especially as kids. And I just have a hard time telling this person they can't practice when it appears that she's done everything to right the wrong. I mean, yeah, it was a felonious act, but I don't know that shows a history, of long-term felonious acts. She committed one crime, she's paid the price, and now we're talking 13 to 14, 13 years later from the last time it happened. And I just personally have a hard time saying no to this request. And I assume that we are able to, we're not going to violate any of our state laws by granting this person a license in Tennessee. Is that correct?
That's correct. The board can, someone can make a motion to approve the license if they'd like to, and I think that's why Wendy wanted to bring it before you guys today to help make that decision.
Yeah, and that's why I was asking the question. To me, the phrase history of felonious activity would be more than one.
Right.
And
I mean, I would be glad to make the motion to grant this request for licenseship for Tennessee, based on the fact that she's righted her wrong in the past and does not have a history of it, and That would be my motion.
I'll second that.
Roll call vote.
Larry Elmore,
Aye.
Andy Bonner,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Judy Weatherby,
Aye.
Motion carries.
Can I ask a question?
Yeah.
She voluntarily disclosed that she had had this issue in the past on her application, right? The one we just.
Correct.
So if she hadn't done that, would we've caught this?
No.
We do any kind of background checks on candidates?
I don't believe anyone in the department does.
Our motor vehicle division has a question on their application where they can check if they've had been convicted of a crime or a felony. Typically, the motor V staff will double check on the Tennessee felony search, but that board sees a lot more felony convictions than the accountancy board, so they really do look through every single one. I think for this board, it's pretty rare. So I think the consideration of the staff's time to check every single one, it would be up
I
to
think if they
whether or not
committed
that
a
was worth
felony
it.
while they were licensed, that somebody would report that to this board, I would assume.
Typically, we do find out about those at some point. Sometimes it's later than we would like, but
So, I mean, I don't know. I mean, I don't know that we know that there's not been that many. I mean, how do we know that there's not been that many if we haven't typically checked? I mean, because people could just not disclose it, and I don't want to put a burden on the staff in any way. I'm just curious, because if they don't disclose it, we would never know.
Wendy, is that something that they have to fill out with their testing or with NASBA before they?
they do fill it out in the testing process, and then again when they apply to us. So they have to answer the question
They answer a question.
couple of times. But
If they answer that incorrectly, that's pretty serious.
yeah, and that would fall under our violations about obtaining a license,
Okay.
and with deceit or
And so someone would basically we would just rely on someone to report them. Is that right?
right.
Okay.
Right.
Okay, the next item is consideration for allowing the Certified Financial Services Auditor exam for CPE credit. Philip Matheny is requesting this. Looking through the materials here, there are probably 10 or 12, maybe more than that, other similar certifications that we have allowed credit for in the past. This one was through the internal auditor, of internal auditors, which is a reputable group, and looking at the materials, it appears to be very similar to what we have approved in the past for other types of exams. Now, one question I had, I don't know if anybody here can answer this, but on page 2 of the email, up at the top it says, for earning your CIFSA, you have earned 40 CPEs, 20 of which are applicable this year and 20 of which are applicable to next year. How could you apply 20 of those credits to a future year?
Larry, I think that's just for purposes of their organization, not for the TSCPA, or not for Tennessee State Board.
For the internal auditors group.
Yeah, just for their own certification.
It's kind of odd, though, to say,
Well, yeah, I saw that too.
you're going to amortize it, I guess.
I guess, yeah.
It's probably that you can only have a maximum of so many from
20
exams
per year,
and
maybe?
There's
in the
just
year,
20.
so they carry it over.
Yeah.
Okay.
There's,
I'm
I think
guessing.
it was 20 per year, subsequent to that, so I assume they're assuming because all the training.
It's a very reputable organization, and I would think we would want to approve that.
Moved.
I'll second.
Larry Elmore,
Aye.
Andy Bonner,
Aye.
Pamela Church,
Aye.
Stephen Eldridge,
Aye.
Judy Weatherby,
Aye.
Wendy, I'm not sure what we're supposed to do with this last item. It's just on here.
All right, you want me to explain?
Please.
Hey, real quick, I just on that, I guess when we approve stuff like that, do we have to designate the category in which it goes into?
Oh, we've done that in the past. However, all of them have fell under technical at some form or fashion. But
like this is internal audit, is that right?
Well, it's granted by the internal audit group, but it applies to being if you notice, they had to pick a category, and this particular person picked financial services, which would lend you to believe they were an internal auditor for a bank or a financial institution. So, but yeah, it's an internal audit type stuff.
So for that person, it wouldn't matter.
Does anyone have a problem with it being technical?
I don't think it matters for that.
Okay.
But I'm thinking public, where you've got to have so many A&A hours or something like that. If he's in private, then it shouldn't affect him at all. He's just going to have.
The outcome of this, though, is that this exam will now be put on the list, and anyone can then use it for CPE. So we should likely designate where you all would like it to fall.
I just don't know enough about it to say whether or not it qualifies as one category.
I would say it'd be technical. Would be my response. And a lot of public accountants and public firms have this designation also. It wouldn't just be limited to internals. And so it would be very technical.
It's auditing things like investments and loans and all kinds of banking type.
It could lead itself, though, to a test work, right? Heighten your understanding and awareness of, enhance your skill set if you're an auditor, per se.
If you're a public accounting auditor, it would.
I understand that, but my point is, if this goes on a list and I'm an auditor, and I say, hey, I took this test, I want it to count towards A&A.
I think we need to know that.
If you look at the syllabus or outline of the course, I mean, I think it would all, substantially all of it be A&A.
Right.
I mean, it's...
I'd be penalized if it was technical, if they were in public accounting.
Well, if you looked at the question 6 says check the field of study which apply to your course, and accounting and auditing are checked.
Okay. But that's not where she was going to put it.
Yeah.
But if it's going to go on a permanent list, you don't want people claiming different categories, would be my thought.
Yeah, I mean, the title of the certification is Certified Financial Services Auditor, so it's probably audit and accounting.
Well, doesn't the syllabus indicate that it's 25 to 35% financial services auditing specific to that industry?
Still auditing.
But still, yeah, it still would enhance their ability to conduct audits if they were in public accounting.
And another part of the syllabus in Domain 2 has an additional 25 to 35% for auditing financial services products, which sounds to me like
present any problems for you? I mean, if it...
No, not at all. I think that likely, instead of modifying or changing the last, can we just get a new motion to accept this to count for the accounting and auditing? Okay.
That was me. I moved that this be allowed to count for the accounting and auditing section for continuing education.
I second that motion.
Roll call vote.
Larry Elmore.
Aye.
Andy Bonner.
Aye.
Pamela Church.
Aye.
Stephen Eldridge.
Aye.
Judy Weatherby.
Aye.
Now, back to Wendy's
Okay.
explanation of the ethics course outline.
Okay.
So, can I ask one more question before we do that? Can I ask one more question?
Sure.
Kind of related. Do we let continuing legal education count for CPE for people who have the CPA and a law license in Tennessee?
We have accepted it before if the sponsor meets the sponsor requirements. So if they're registered with NASBA or they're an exempt sponsor.
Okay.
And we also have a provision where you can submit up to 16 hours from a non-registered sponsor that then we approve separately. So you couldn't get probably all of your education that way, but there are some carve-outs where you might be able to count some of that.
Yeah, I think you're only required to get 15 a year in Tennessee from a legal standpoint.
Oh, okay.
So that would work. Okay. I know Mississippi has a thing where they just all CLE is counted, no questions asked. Yeah, as long as it meets the legal standard that they accept. I just didn't know if we did something similar here or not.
No, but maybe something worth considering.
Well, it sounds like you can do it. So
yeah, for the most part, yeah, especially when you can do the 16 hours that don't necessarily have to be from a sponsor.
Yeah.
The thing about that, though, Gabe, that we'll see earlier is it has to be approved in advance of attending. So if somebody attended it last year and then wants to claim it but didn't go through a pre-authorization process, then they wouldn't be able to count it.
All right.
Got one more, Casey.
Got one more item, but I appreciate the early.
Well, you're going to let Wendy handle that, so you're through it. Good job.
Basically, yes.
Yeah.
Okay, so the last item on this committee's agenda is a state-specific ethics course outline. So as part of our agreement that we're working towards with TSCPA for them to provide the state ethics course, one of the obligations of the board is to come up with an outline that they would then follow in creation of that course to make sure they're covering the items that this board would like them to cover. So I drafted this and needed to get y'all's input. I believe Sherry's looked at it. I have also exposed it to TSCPA, and we made a slight revision or two in those conversations. So what I'm interested in is if you approve this particular outline for the 2018 course.
That memorandum of understanding, and you called it agreement, but I think it says it's not really an agreement. It's a memorandum of understanding, but one of the items there says we will provide this outline to them by February 28th each year. It's early in the calendar year, I believe, but I don't remember. Was it by February 27th, 28th?
That they would provide the final course to us. Is that correct? This is, we are required in that memorandum of understanding to submit this to the TSCPA by December 1st. And then they have 3 months.
By February 20th, they then have to incorporate that in their agreement, yeah.
Right.
Yeah.
So how does this differ from the 2007?
This is just more specific, gives them more guidance on the things to include.
They're already offering this course, aren't they?
Right. And for the most part, from my understanding with CARE, they pretty much have these items all covered.
This will be an annual thing we'll
Yes.
have to do as part of that memorandum. In other words, this time next year, we'll be looking at and it might be the very same outline, but if there are any changes or anything, we'll have a chance to at least tweak that or add it to the outline each year. So.
Right.
But when you were reviewing this, did you, and I'm not sure how you would do this, but kind of review when we've had the complaints?
Yes.
If those fines and the nature of those complaints are covered in here so that as people are taking this course, we can say, okay, you have to take this course. You should have learned all of these things that there may be complaints or fines against, so that, there's there's limited excuse, I guess.
Right.
Yeah.
So basically, yes. I mean, part of what I think about is, of all the complaints we've seen and all the issues that we've had, are we addressing those in here so that people in the future see the things that they need to make sure they're paying attention to? And then the last item talks about case studies, enforcement case examples. So we are certainly willing to specifically take some cases from an anonymity standpoint and use those as case studies within the program. so that they can see actual things that have happened, which is what we've done with our program in the past.
Wendy, I spent some time looking at this outline. I think it's very comprehensive. I mean,
Absolutely.
I did not see anything I would add to it or take away. I think it's good.
Remind me again, all our other providers are set to expire at the end of this year. Is that correct?
12/31, correct.
And we had some issues where people wrote us back in. Have we resolved all that? We haven't heard from anybody else, other providers, right?
No, I've had a couple of conversations about the board's final decision, and everyone seems respectful of the decision, whether they agree or not.
Good. Good. I'll make the motion to approve the outline for the Tennessee State Specific Ethics course.
Second.
I'll vote.
May I ask for one more discussion point? May I ask Kara quickly if she has any comments before they make a final vote?
Anything else? Wendy had shared that with us, and we reviewed it and asked a few questions specifically about the statistics related to licenses, and just wanted to know if the board would be providing that to us to make sure we have up-to-date and accurate information, and asked about the enforcement case studies and how we would go about gaining that information. So I think it looks good. It's very comprehensive. The online course we have right now, I feel like addresses most everything that's in that outline. We might want to add just some additional information to enhance a few specific areas, and it won't be any problem to incorporate the items in that line into our live course either. So.
Wouldn't mind stating your name and where you are from. That's okay.
Kara Fitzgerald, Tennessee Society of CPAs.
While you're in front of us, how is the new course going? Are you getting good feedback from it?
Yes,
any complaints?
The online course, the participants are not required to complete the evaluation in order to get credit. So not everyone who takes it submits the evaluation, but the evaluation comments that we have gotten have been very positive for the online course, that they like the interactive nature. They like the ability to take it, at a time that suits them. So far it's been positive feedback.
If there were any negative, I'm sure you would have gotten them. So, I mean, generally that's what you get instead of the positive. So it must be very good.
Thanks, Karen. Okay, roll call vote.
Mary Elmore.
Aye.
Andy Bonner.
Aye.
Pamela Church.
Aye.
Stephen Eldridge.
Aye.
Judy Weatherby.
Aye.
Hey, quick question. You can come to our board meetings and get 1 hour of state-specific ethics, right? Is it
Yes.
just the board meeting, or is it? They don't have to come to committees and all that, right? Just the actual.
It's just
board
been
meeting.
the board meeting is what
But they have to sit through the whole thing, not just 1 hour of it, right?
that's how we've handled it in the past.
Gotcha.
Okay, Mr. Chairman, we're now finished with the licensing committee.
Good job,
Thank you.
Larry.
Thank you.
Yes, Gabe, you're up next.
All right. We have two items on our on the enforcement committee agenda. The first is to go through complaint statistics, and I will turn that over, I guess, to the legal counsel to go through those. Or Wendy, is that you?
I put it together, so
Okay. Go for it.
I'll go ahead with any input that they may have. So if you pull this up on your iPad, it's complaint numbers. In the first section of this document, you just have by month the number of complaints that we opened, the number that we closed, and then the general area in which those complaints fell. You'll notice in July that we opened 10 for failure to comply with the CPE audit. June 30 was, I believe it was the beginning of June was the deadline. They got an extra 30 days. So by the time we came to the end of June, anybody who had not responded had a complaint open against them. Down to the quarterly numbers, you will see kind of a running balance from July to August to September, how many we had total plus those opened and closed, just to give you an idea of our total numbers kind of in the pipeline. As of October 1st, we had 68 total complaints. 31 of those are going to be on your legal report today. You'll see on the right side there, the small box fiscal year numbers. That gives you a sense of the fiscal year numbers at the end of each year, June 30. So June 30, 17, we had 97 total complaints. Now, it does look higher than the previous year, but as you will notice, and I think I mentioned at the last meeting, we have automated a lot of the complaint processing, and so you will notice more complaints that indicate no jurisdiction. And those are complaints that come in that just have nothing to do with the accountancy board. So they are automatically closed and then referred to maybe consumer affairs or wherever else might be able to help these folks who have a complaint of sorts. So it brings our numbers up a little higher than we might expect. The very bottom on the left is status of open complaints. Those are the numbers of complaints maybe in each step of the process. From receiving the complaint to requesting a response, we refer it over to legal, they review it, they may or may not ask for an investigation. Once they receive the investigation back, they will present on the legal report with a suggestion to close or possibly authorize for a formal hearing with authority to settle. We have some that have been issued consent orders, well, actually not at the moment, that haven't complied with those. You have some that are in litigation monitoring, and then we kind of get all the way at the bottom where some folks have signed their consent orders and have agreed to payment plans of their civil penalties. So overall, just an update on the numbers. So are there any questions?
I wonder if for benefit of maybe members that weren't on the board 2-3 years ago, if you comment on the 2015 total complaints were 197, and that was down to 77 the next year. And could you give the board some insight into that decline?
Sure. The large number for the fiscal in June 30, 15 is attributed to a couple of things. There were a significant number of professional privilege tax cases out there. So previously, if someone had not paid their professional privilege tax for a number of years, we opened complaints against them and had to resolve those through the complaint process. Now we're in a place where we can hold their renewals, and we don't renew their license if they're delinquent on the professional privilege tax. So we no longer handle that in the case and complaint process. The other factor there is also at one time there were a number of complaints opened against individuals that were performing tax work, I believe, without doing so out of a licensed firm because it was interpreted that was the requirement. Since we have clarified that that's not a requirement, so there were a large number in both those categories that happened during that.
Is that the year Texas referred all those cases to us too? It seems like 1 year Texas sent us a ton of cases.
No, I think it was primarily that PTIN number that our previous, I guess he's executive director somehow got a list of PTI people in Tennessee that had PTI. Turns out we were going down a dead-end trail on a lot of those. I mean, we opened the complaints and then turned right around and closed them, and like Wendy said, we figured out that was not a good process we were going through. But I guess if you look back, I don't know, prior to 2015, if you look back to 13 or 14, the number of cases would be, I think, cases open would be less than that 197, significantly less. So just a temporary 1 year spike up in those numbers.
Gabe, before we go on to the legal report, if we wouldn't mind clarifying who's here on the enforcement committee by roll call.
Sure.
Karen, do you have them?
I believe I do. Gabe Roberts. Janet Booker Davis.
Here.
Pamela Church.
Here.
Larry Elmore. Here. Kevin Monroe.
One other question. Do you see any growing need or anything for investigators? Are we good in that regard based on kind of where we are from a complaint standpoint? Is there anything that has changed in the last year or so?
I think we are doing great. Since Sherry's been on board with us, I noted here that she has performed 17 investigations. So we've been doing great, and she's been timely, if not ahead of schedule, on all of those. So we're doing well.
Great. So the next item is the legal report, our favorite time-honored tradition here to go through these. And since the last meeting was a little over 2 hours on a Thursday afternoon, trying to figure out how to speed this up some. And so a couple ideas. Our legal team has been willing to take one for the team today and not be prepared, but at my request, they're actually going to go spend the time going through each of these items, not reading them, but giving us pertinent facts and summarizing them, because I think there's a good number of these that I would probably spend more time than needed to, and we're going to follow the recommendation or whatever it is, and it's an opportunity to speed up the review and get to the substantive pieces that we really need to sink our teeth into. So, also for next time, preview of something else to come, we're going to try to see if we're okay putting all the recommended closures on some type of a consent agenda. And you can look at them ahead of time, and if somebody wants to pull them off to talk about, we can do that. But otherwise, we can just speed through those 8 or 10 or however many there are, trying to speed up. So for that, I'm going to turn it over to legal to start off.
The first case is mine, but I did want to it's a sad announcement that we've restructured a little bit in legal again, and I will actually be rolling off this board. So I will still be with the department. I'll still work every case that I have opened with you all, as well as some of the higher priority cases that Matt may have had, or Ben, anybody else before me. So I'll still be definitely around, but I won't be presenting any new complaints to you all after this meeting. But I wanted to thank you all for your letting me work with you. I've had a great time doing it, and I won't be a stranger, that's for sure. So, anyhow,
well, thank you.
We get to vote on that. We should get to vote on
another.
I didn't get to vote either, honestly. So
another time-honored tradition is we've had great legal representation, especially the last few years. So we appreciate that.
Absolutely, so, and Shalina will be here, so no worries there.
That's great. So the first 8 are recommended closures. If you just kind of give us a high level of each of those, again, it can be as quick as possible.
Absolutely. The first one here, this is a case where you have an ongoing estate dispute, and one of the members complained against an accountant that was asked to do some work. All she did was reach out to an attorney to make sure the document was going to be in the proper format, and there was no exchange of confidential information like the complainant stated. So there was no merit to this one. So we asked for close on that one. The second one is also mine. In this one, this was a case, this is a little different. Is an individual who didn't report to a CPE audit. However, they have closed their license kind of during the pendency of that audit. And so there's not really a license to attack at this point. But what I recommended was that we close, but then flag it in our system. And if that person wants to reactivate at any point, only the 2 hours they had outstanding, which is just this 2 state specifics, they would have to submit those, as well as whatever would be required at reactivation. I think the rest are Shalina's in closure.
The next one is 20170193991. This complaint was filed against a respondent CPA on behalf of a complainant's business that had retained accounting services. It alleges the respondent failed to exercise due professional care in completing the accounting services, and the complainant states that the respondent should have brought evidence of the unusual account activity in the business bank account. Namely, there was $224,000 of fraudulent transfers made between the period of January 2014 to September 2014. There was also past due IRS taxes, and as a result of all this, the complainant had to pursue bankruptcy protection. The respondent provided a response and denied all the allegations, and stated that the respondent was hired to provide tax and general accounting services. There was an investigation conducted, and it was determined that there was no wrongdoing, and the respondent returned all accounting records and documents, and they had not been engaged to provide any payroll services. And all notices were sent directly to the complainant, so the respondent didn't have any knowledge. My recommendation is to close this one.
I also even mentioned that the respondent had forgiven fees and stuff that were owed to them in this situation. Isn't that right? At the end of page 3. Our balances owed to him or his firm in the contract. I mean, it sounded like the respondent had
Yeah,
done
he
everything-
forgave,
Yeah,
the
they could
respondent
do,
forgave the remaining balance that was due by the complainant.
Questions from the committee on 3? Okay.
The next one is 2017-044-701. This complaint was received from the son of the client who had engaged the respondent. The respondent was hired by the complainant's mother who owned the business, and that business had recently been sold. The allegation is the respondent refused to turn over business records, destroyed documents, failed to cooperate with a subsequent CPA, to finish tax returns that were due. As a result, the complainant's mother had to spend an additional $4,000. There was also the allegation that the respondent didn't properly file the 2015 tax return, and there was numerous mistakes on the 940 payroll taxes, and respondent didn't provide adequate notification that taxes were owed by his mother when the respondent was requested to fix the problem. This respondent provided an extensive response and stated that the complainant is actually an accountant and works at a CPA firm in Georgia and doesn't have an interest in the business and was not the respondent's client. All documents were returned to the client every year, and the subsequent CPA that took over the work also was provided the documents and told that they were sent to the client on numerous occasions. The penalties that were assessed to the complainant's mother were because of failure to pay the estimated taxes. An investigation was conducted, and there was no conclusive evidence to support any of the allegations, and my recommendation is to close this matter.
Questions? Okay.
Next one is 2017-027-131. A complaint was filed by a consumer alleging the respondent was engaged in an inappropriate relationship with her father-in-law while providing accounting services. The complainant is married to the son of the client of the respondent, and they reside with the father-in-law. The respondent provided a response and stated this was a personal matter. The father-in-law was actually the ex-husband and advised her not to turn over any documents, and the complainants have no legal right to any of these documents. Following an investigation, a durable power of attorney was obtained for the father-in-law, and the father-in-law's sister was appointed the power of attorney, and the respondent was listed as the contingent power of attorney in the event of the sister's death. My recommendation is to close this matter.
The issue here was that the complaint was that the CPA was the CPA for the father-in-law, but also was the attorney-in-fact for the father-in-law, when in fact that's not the case. It was the daughter who was the attorney-in-fact for the father-in-law. Is that right?
No, the daughter-in-law and the son had no power of attorney or any authority. It
So
was
I'm saying, so they weren't the attorney-in-fact through a power of attorney. It was somebody else.
It was the sister
Okay.
of the father-in-law.
Questions? All right. Go number 6.
The next one is 2017-046-781. A complaint was filed against the respondent stating the respondent failed to provide a copy of the 2015 tax return prepared by the respondent and failed to return the documents. The complainant had received a letter from the IRS for information for an audit of that 2015 federal tax return, and the complainant was required to provide additional information to support Schedule C. The respondent provided a response and stated that she did not prepare the tax return and referred the complainant to another firm that would handle the matter, and this respondent had nothing to do with the preparation of the tax return. Upon a review and investigation, it was revealed that the respondent did not prepare the complainant's tax return. My recommendation is to close. The next matter is 2017-050-951. A complaint was filed against the consumer a complaint was filed by a consumer against the respondent, stating the respondent was holding the complainant's tax information and failed to file the tax returns. The complainant alleges that the respondent has all the documents and will not return any of the phone calls or the documents. The respondent has been in contact with all of her clients, and in particular, this respondent did receive a federal and state of North Carolina tax returns, and they were completed and filed. The respondent had been in communication with this complainant, and due to some health issues, there was an extension filed, but all the tax returns were completed by the deadline of October 15th, 2017, and my recommendation is to close this matter.
Questions on this one? Okay, let's go to the last one, number 8.
2017037741. A complaint was referred by the Tennessee Society of Certified Public Accountants. The respondent was dropped from the peer review program. The respondent has not been reinstated. However, this respondent is deceased, and this has been verified, and my recommendation is to close.
I just had a question. There's no one else going to take over this firm?
We didn't find any information that anybody was taking over this firm. I believe it was the individual CPA who is deceased who had the firm.
It was a sole proprietorship.
Okay, and his wife or something. Nobody
Well,
else
he
was
was
gonna do anything.
Not married.
Okay.
If there's a change in ownership, does that have to come before you all to approve?
A change in ownership of another firm, yes.
So if this somehow went to somebody else, they'd have to come before y'all, and y'all would know that they need to enroll in peer review?
Now, that'd be change in ownership, so they may take on the clients and
What about the firm permit? I mean, is it expired too?
It would be closed too with the deceased, yeah.
Right.
So
Apply for a new firm permit is my point.
right, if it was somebody who had not done work before and kind of bought the practice, I guess, they'd have to apply for a new firm permit, yeah.
Okay, so I guess let's go through them all, and if that's okay with the committee, and then we'll just make all the motions at the end. Is that okay? Can we do that? Is that fine? Okay. All right. So the next two are recommended letters of warning, number 9 and 10.
Yes, number 9, 2017-057031. This was an individual who is is new to the country and started a business that included the word accounting and was turned in by a competitor. I reached out to speak with him about this, and he was very quick to fix the problem almost immediately. Even in his response email, he had changed his signature block at that point. He's currently taking the CPA exam and intends to be licensed with us, and didn't understand the distinction. So now he does, very friendly and cooperative. So I thought a letter of warning seemed most appropriate here.
(2017049901). This respondent was selected for an audit for the 2014-2015 CPA reporting period. The respondent has failed to provide proof of the required hours by the required deadline. However, on August 8th, 2017, the respondent submitted an email with an explanation and stated the information was provided in a timely manner. However, the certificates of completion were not submitted because there were CPE from legal conferences offering CLE. The respondent provided CPE for 2012-2013 of 162 hours and CPE for 2014-2015 of 80 hours. The respondent completed 116 hours of CPE for the 2016-2017 CPE reporting period. Respondent admits to missing the deadline for reporting. My recommendation is close upon the issuance of a letter of warning for failure to respond to the audit in a timely manner.
I got a question about this one. I've seen this a couple different places on this report. It looked like what we were part of the consideration, and I'm not making any type of qualitative assessment on this, but part of the consideration was that the individual has the license from us but isn't actively engaged in the practice in Tennessee. And I'm trying to buttress that with the conversations we've had around fictitious names because I want to be consistent. And so what we have said, even with some of the groups that have come before us that don't do the test services, but they want the firm permit, and we've always said, while I personally am loath to go in that direction, we're willing to do it because it brings them under our purview. But I just want to make sure that both ends are kind of talking to each other, because if we're going to do that in one instance about bringing them under our purview, even when they don't have to be under our purview, then at the same time, if there's somebody who has a license from us, even if they're not actively practicing, they still need to comply with the license requirements, right? I mean, I've got a half a license in Mississippi, and I've never practiced there one day in my life, but I would be potentially disbarred if I didn't comply with the stuff there. So I just want to make sure we're considering that from a staff standpoint, that we're being consistent. And I'm okay. I mean, I'm not saying this is bad, but I think it's worth us talking about to figure that out. I don't know if the committee has any other thoughts on that or not.
Kind of restate your main point.
So in here, it looks like they didn't quite comply with the reporting requirements of CPE for some past years. And we looked through it, and one of the reasons all we're going to do is issue a letter of warning on is because the person isn't involved in active accounting or test work. They do litigation support services, and they're not actively engaged in a test work in Tennessee.
I don't think that's what this particular case is. They did meet the requirements. They just didn't respond when we initially requested the documents because there's some health issues going on with family members. And so the complaint was open because we never received the response. Once the individual did respond, they had met all the requirements for a number of years. And so the only reason we recommend, or believe legal is recommending the letter of warning, is because, in fact, they did meet the requirements. It's just that they didn't respond when we initially requested the response,
Okay.
so, which is a violation. But
well, what I read, and maybe I'm just reading it wrong, but it says the respondent admits to missing the deadline for reporting. So when I read that, I think the initial report, not a response to our audit. Are they different?
I think that that's just missing. The writing was probably not correct.
Okay. Well, that's what I was concerned about. The response to the audit piece I get, but even if you're doing the CPE, but you're not reporting it on time within the deadlines, that to me seems like a problem.
It's missing the deadline for reporting on the audit, not the CPE.
All right. Okay. I see what you're saying. You can describe my comments. I thought we were talking about not reporting them when you're supposed to report them biannually or semi-annually, whenever you do it. Okay.
When you renew your license, you attest that you've met the requirements, which the individual did. And then when we requested the actual documents, they did not respond by the deadline, and therefore we opened the complaint.
Okay.
So when we went back, the person indeed met all of the requirements. They just failed to respond, which is a requirement.
Gotcha.
My question, though, would be is why do we even put that in there when the respondent does not reside or practice in Tennessee? Because to me, that's not I mean, they have a valid Tennessee license, right? And therefore are required to abide by our rules.
Most individuals include that in their response because it's their way of saying,
I'm not sure whose language that is.
well, typically we wouldn't know that unless they put it in their response.
Seems like we're using that as a reason why we're not
I gotcha.
punishing them any worse than
Right.
we are. And so it seems like, well, that's not really a reason why we shouldn't. If they have a valid license, then that would never be an excuse.
Yeah, that was my point about the earlier.
I agree with you. Yeah. And I think in our meetings about this, my particular viewpoint was that the person had met the continuing education requirements on time. They had just failed to respond to the audit, and that's the only issue we probably need to be looking at.
We do typically, sorry to interrupt you, we do typically try to include, even if we think it may not be worth the wait, we try to include what they said, because what happens otherwise is they get the consent order and they'll say, well, what'd you tell the board? And then we'll show them the legal report entry and they're like, well, you didn't tell them this, that, and the other. And then we get in a position of, well, maybe the board would change their mind if they knew that fact. So we do try to include it, at least any of the mitigating factors they allege, with you all obviously getting the option to give it no weight or some weight. However,
I only consider that one because if I read this and the way we've responded, somebody's going to come back and say, well, I don't do that work, so these rules just don't apply to me.
Which people do say. We
Right.
do hear that from some people.
That's
So
like,
you are right.
then you need to get rid of your
Correct.
license if that's the case.
Exactly.
Okay. Any other questions? All right. So now we're moving to the section where recommended consent orders, and this is what I would think we need to kind of sink our teeth into to the extent that there's some questions. There's largely, it looked like to me there's two big themes. A lot of them were either CPE related audits and peer review issues, a couple of peer review issues. So, number 11.
Number 11, 2017-048-021. This is a classic non-response to an audit. And so, therefore, the penalty is the full $1,000 we normally request, all hours that we would normally request, including penalty hours. And then Wendy had us add this last sentence, which I think is really good to add, which is to make sure that we're clarifying that all these hours are penalty hours. So you cannot come back later on your renewal or any sort of reinstatement and try to say that these have counted towards another bucket you need to fill. So we're going to try to add those consistently going forward to make sure that's clear to people. Number 12 is also mine. This is a situation where the CPA, AICPA notified staff that the respondent had been terminated from peer review for failure to complete corrective actions. In 2016 is respondent's last renewal, and on that renewal they indicated that they were performing a test work. Nothing has been filed with us to indicate that they're not performing a test work. So that leaves us with the situation of someone who has declared that they're actively performing a test work but are now no longer enrolled in peer review due to termination, which, as you know, is not a good look. So the respondent did respond to this complaint and stated that their failure to respond to AICPA was due to a short deadline, and that he is in active litigation due to being sued, and so therefore all his time and effort has been involved in defending himself and his assets. He says he does want to resolve the issue if possible, but didn't really offer a solution. So as of when I last reviewed this entry, respondent is still not enrolled, but respondent has been enrolled before in 2008 and 2014. And you can see up in the history there in 2015, this respondent received a $1,000 civil penalty for failure to comply with peer review. So this would be a second violation of not being enrolled in peer review when it's required. I requested the penalty of $3,000 for failure to be enrolled in peer review, and additionally that the respondent provide proof of enrollment or submit an exemption form within 30 days.
Second time the person's been out of compliance with peer review?
This is the second time, that's correct.
Don't we do the $3,000 settlement for the first time offenders?
We do that because typically it's like per year, and in this case, because of the termination date, we're actually not up to a full year. Wendy and I kind of talked about this when we've struggled on what would be the most appropriate penalty in light of the fact that while it is a second offense, it's not like the ones we usually see where they've never been enrolled. He was just recently terminated, I believe, and so there hasn't even been a full calendar year that he has not been enrolled. So I tried to take that into consideration when I suggested the $3,000 penalty, but I'm definitely open to ideas on that one.
It seems to me like if we have been recently doing $3,000 for the first offense, it should be more on the second offense. I don't know what that number is, but I mean, also, it's my opinion. The community members could have different opinion. I don't know.
You have had a peer review in 2011?
I believe so. Yes.
Oh, he didn't have one, or?
No, I think that the history reflects that. I know the timing seems off, but sometimes things at that time took a while to get through the process. And so I think the violation that you see from 2015 is actually part of him not having the peer review that he should have had.
Would have covered the 2011 period.
Anybody else think that it should be higher than $3,000 or not? Am I alone?
I would agree with that. I don't have my penalty matrix.
This is $1,000.
It's on the iPad.
It's been a second offense. Is there any precedent on that?
not in my working memory of the board. This has been the first time that I've had someone come back up again, especially as so close in time in this fashion. I will say the penalty matrix contemplates $1,000 per violation, which can be per day. And so I think that gives you quite a bit of leeway. Something we had talked about is $1,000 per day since the date of termination and counting as we move towards a formal hearing. And that would honestly, if we went to a formal hearing, that would be what I would plead for and allow the judge to make a determination on what would be appropriate. So I think we could go up from there. I know it's not factually similar, but at least for a penalty amount, we did have a person produce an audit while unlicensed, not in peer review, and we did $5,000 in that case, just because the nature of the audit, what it was used for, was egregious. And so considering this is a second offense, maybe there's a parallel there to say 5,000 is more reasonable.
I mean, my thought was 6,000 because if you do 3,000 a pop and it's the second time, it's 6,000. But that's my thought. I don't know. I would defer to the practitioners here to understand what you think is best.
We had prior discussion where we had arrived for a first time offense at 3,000 as that being a proxy amount for what a smaller practitioner might pay for a peer review. And so, that made sense to me in that sense. But I wouldn't be averse to moving to $5,000 or $6,000 in this case because it's a fairly, it's a second offense in fairly quick order or short order from his first offense.
All right. Does anybody want to make a motion?
I would move that we accept the recommendation, except with respect to the proposed civil penalty of $3,000, that would be $5,000 as a proposed civil penalty.
Second.
All right. We're going to go ahead and let's go ahead and vote on this one since we're changing it, and that way we can keep track. Is that okay, Karen? Can we do that? We need to do it through roll call. Are we all present?
No, because Stephen's not on this committee.
Okay. So, motion and second. Is there any discussion? All right. All those in favor of accepting the recommendation but changing the proposed penalty to $5,000, say aye. Aye. All opposed? All right. Next.
Number 13, 2017-04-6701. This is another audit with a failure to respond. They did ultimately respond to the complaint rather than to the audit, and stated that when she renewed her license in 2015, she realized she hadn't completed her CPE. She said that she attempted to get caught up but was ultimately unable to do so. She then requested her license be set as inactive. We actually you'll see that again. We've had quite a few this group this time around asked to go inactive, and kind of going to what you all were talking about earlier, we made the decision amongst ourselves, and I think in line with what this board would do, that really going in inactive today has nothing to do with what you were required to do prior to going inactive. So for those reasons, I stuck to our typical non-response, non-submission recommendation here.
Questions on that? All right.
Number 14, this is again an audit, 2017-04-7461. There was some proof submitted by the respondent of CPE. They submitted 34 hours for 2015, 23.5 were technical, 10.5 were non-technical. So there's still outstanding hours. The respondent says that this absence of hours was due to a new role that was travel intensive, so that they fell behind, but that they will make it up. And so I have assessed $1,000 penalties, and then as you can see here, the breakdown of the remaining hours that are required, plus penalty.
Any questions on this one? All right, 15.
15, this one is more substantive, and it actually encompasses two complaints related to the same CPA and CPA firm that is owned by the CPA. I'll start with complaint 1. Complaint 1 was a board open complaint due to the respondent firm issuing a review report without an active firm permit. Additionally, respondent firm was not enrolled in peer review. The respondent firm indicated on his initial application that they did not perform a test work, and the firm responded to that complaint saying the renewal was just an oversight by an office manager that had left the firm, and so it was missed, and they did ultimately renew it after being notified of that discrepancy. And but they didn't really address peer review. So Sherry investigated this case for me and reached out and spoke with the respondent. And it seemed clear to us that this is a young CPA who struggled to understand how a review was audit work, but ultimately, hopefully, they understand now. And so at this point, I don't know if I think he is enrolled. No, we don't know. They have not enrolled in peer review, and they have not submitted an exemption form yet. And it was also noted by staff that there's a couple places where they refer to themselves as "and associates" in their title, which is not a licensed name. So that wouldn't be allowed because it's deceptive. It indicates multiple CPAs are at this firm when really it's just the one CPA that's there, although he does have other employees that help with tax work. So for complaint 1, I requested the authority to settle via consent order for a $3,000 penalty for failure to enroll in peer review, and additionally, the respondent will have to submit proof of enrollment or an exemption. And I also requested a letter of warning in regard to the unlicensed DBA name. And I did that because you'll see in the second one, I'm just trying to take it as a holistic approach here. So complaint 2 is a little more complicated. Complaint 2 is a complainant initiated complaint from a client. She stated that the CPA had failed to communicate with her and that her tax returns were not prepared with due professional care, specifically alleging that the client was not able to get her original documents but only received copies, that the firm charged her twice the estimated cost, the respondent firm and CPA failed to set up a payment plan with the IRS or make necessary follow-ups, that the CPA failed to file her required Colorado state tax income return, and that the respondent CPA did not treat the advance payment of the premium tax credit obtained through this ACA exchange properly. And that she was also upset that when she met with the CPA, she thought she'd only be working with that CPA, but ultimately was asked to work with other members of the firm, and she was not satisfied with that. We concluded most likely because previously she had one CPA that did all her work for her. This respondent did respond to this complaint and said that explained how the billing went, that the original estimate was just that, an estimate, and that things due to the complications of filing the tax returns and communicating with that client ultimately led to the rise in cost. Sherry did conduct an investigation, and Sherry didn't, I think she kind of confirmed the respondent there didn't seem to be any billing discrepancies necessarily. However, there were errors in the returns. The respondent put complainant's work address rather than her home address on the return. Form 8962 was not completed properly, resulting in a higher repayment amount than required, and complainant's Colorado return was not filed. Respondent told complainant not to worry about that return because, quote, none of your income was reported to them, no need to add more debt to you. Respondent CPA claims that complainant would not confirm the date she lived in Colorado, and he even questioned whether she was being truthful about living there. But ultimately, Sherry made the observation that there wasn't any follow-up to attempt to confirm those addresses, that he based the thought that she hadn't lived there on receiving one other document that had a North Carolina address on it, and made the assumption that meant that she couldn't have lived in Colorado and couldn't have had reportable income for whatever reason. Outside of the allegations from the complainant, Sherry actually identified some other intentional errors committed by the respondent CPA, which is namely deductions provided by claimant for her business that were not included in Schedule C's filed with the IRS. The deductions were taken at the request of were not taken at the request of complainant because she wanted to ensure her business income on the tax return met a target necessary to qualify for a mortgage loan for her home here in Nashville. Sorry, I shouldn't have said where she was from. The need to rush the return, despite the filed extension, was also due to the need to provide documents to the lender, which is reflected in email. So Sherry identified this omission as a potential violation of 62.111A5, dishonesty, fraud, gross negligence, as well as our rule on objectivity, integrity, and not knowing and misrepresenting facts or subordinating your judgment to others. In conclusion, Sherry noted that respondent CPA's lack of inquiry into complainant's residency in Colorado, misstatements in the Schedule C filed as are likely violations of this board's laws and rules. Although we do note that he does seem to be new to the profession with limited experience in managing a firm. But in light of those, for complaint 2, I requested that there be a $1,750 penalty assessed,
1 act of failing to gather sufficient relevant data at $750, and 2, 1 act of misrepresenting facts, subordinating judgment for the deduction omissions on the Schedule C for a $1,000 civil penalty. So that altogether there'd be we would combine those into one consent order. So you're talking about a $4,750 penalty and a letter of warning.
For the complaint 2 penalties, I don't remember something around somebody subordinating their judgment and basically committing fraud at the request of their client. I don't know if we've had that. Have we had these before? Is there anything that we can look to in the past for precedent on that?
Yes, we have had complaints of similar, I guess, subordinating judgment. I have one for you later, but it went to litigation monitoring. Often those cases are involved in civil litigation. This case, I don't have any memory of actually getting one myself. However, the way that our penalty broke down, looking at some of our past allegations, were that $1,000 is the more normal middle of the road penalty, with the possibility of moving up to suspension and revocation. I think in our more significant cases that involve fraud, when we have maybe the SEC notifying us of something or something like that, we've gone for a suspension or a revocation. I don't know if I would, those are the only cases I'm familiar with, and I'm not sure I would necessarily equate those size cases with this one, but I do agree that this is a pretty serious violation, despite the fact that it seemed to be based on a little bit of ignorance of what you're supposed to do.
To me, that's also pretty troubling. I mean, I understand that. I mean, we've all been there before, I guess, in respective professions, but I mean, they're holding themselves out to the public, and the person is where they are, right? And so I have a note that I think we should require some type of CPE to something about managing a firm or something. I don't know. Again, defer to my colleagues on the committee or the board who actually do this for a living, but it's pretty troubling that you've got apparently a firm manager who doesn't know the difference, that doesn't realize that a review is an attest service. I mean, that's pretty.
Your new ethics programs.
This is exactly what we're here for. I feel like one of the biggest pieces is to protect the public, and I think we've got to make a statement, not just to penalize the person, but to actually make it work and make the person better at what they do.
CPE is actually something we had quite a thorough discussion on for this case. We've run into some issues with making sure that folks are one, I can articulate in a consent order precisely enough exactly the CPE required, 2, set a deadline on that, and 3, have them able to find a CPE that fits those check marks. So we've had
this would just strictly be the ethics CPE, right? That would cover these issues.
We could certainly do that.
Right.
You're going to hear from Alfonso from NASBA tomorrow, and they have created a separate course in conjunction with Missouri that would be perfect for this situation, which is why I had Alfonso come tomorrow, that in the future we could use, I'm just bringing it up because it matches, that we could use in the future as a discipline tool for cases just like this. But we're not quite there yet. So yes, the state-specific ethics course is really what we have.
That would distinguish between a test and non-a
yes.
test. I mean,
yeah. You know, the fraud part, I don't know. I mean,
fraud's fraud. I mean,
yeah.
I don't know.
Yeah.
I don't know that taking the CPA is going to fix that problem.
Right.
If you're willing to bend that. I mean, I agree with you. I think the first one, I believe, should be perfectly addressed by the state-specific course.
But there's we had someone in here recently who we suggested take the SARS-21 course.
Yeah, the compilation review update.
Yeah, so that would be a good course that covers reviews and the differences between those. So I agree with Gabe that the CPE would be appropriate. And do the penalties related to complaint 2, do they tie into this matrix somehow?
Yes, the $750 should be a first-time offense for that rule violation, and then the $1,000 is also a moderate middle road for fraud and deceit. So that was an attempt to try to not only stick with the schedule, but also take into consideration what penalties he'll be looking at total, as far as what the position he's put in, all kind of at one time. So, I think we had talked about assessing the state-specific ethics, but then we realized because it's just the one course now, we're really just asking him to take the same class twice because he'll have to take it again for his required CPE. So I tried to go on to some of the online databases and try to find something that's specific to ethics and management of a firm. And
Did this individual have work papers for the review? Do we know that?
Yeah, sure.
He had very minimal work papers. It was like a cash-only balance sheet.
The programs, no.
Just very
Just basically typed up a
minimal
review
work.
report
Yeah.
and said, "Here you go."
Yeah, not the checklist that you normally see, nothing like that. Just basically a verification of a cash balance.
It's a very naive lawyer question, but is there not are there not any ethics courses around standing up to clients and not bending your judgment and learning how to disengage from an engagement to the extent that they don't feel like they can do that? Do we even know? Does AICPA do anything like that?
They have behavioral ethics courses that might address that type of activity. In terms of, a lot of them are case study type things where you could potentially, if you'd have to almost define specifically which CPE you'd want them to take that would go around that particular
The problem that's gotten is now
scenario.
the states do all the state-specific ethics, which really cover more of the functioning of our rules and regulations, as opposed to the true ethics, what you would consider ethics.
Yeah.
If I may add, he seemed absolutely ignorant of the fact that providing a misleading tax return to a third party like a lender, he seemed thought like that was something you did every day.
I almost feel like we should bring this person in and have a conversation with them. Is that possible? Can we do that? Or it's just something that is that so outside the pale that we wouldn't do that?
You do have big ethics failures here.
I mean big, right?
Yeah.
And the fact that it's a person younger and earlier in their career.
I think you would send a very strong message to that individual if you did that. We don't have to do consent, do we?
I mean, you could do revocation and go straight, or you could say that you don't you just want the formal hearing. But my request would be that it would be through the formal hearing process, not an informal conference, just because there's not really a mechanism contemplated. So it would be a hearing in which discipline would be assessed at the end, but you'd have the ability to ask him questions. You'd have the ability to be represented by counsel.
We can't bring him in here to address the consent order
at that point
without doing formal hearing.
I would have to have the hearing be ALJ alone because you would all have to recuse yourself. We can do. But you're going to be putting it into the hands of an ALJ who doesn't understand the laws and rules, so I would need to get an expert witness. And
we can't ask him for further clarification.
We can ask him for. I can do that and do a representation with the new information. I need to maintain anonymity in order to not sully you all, and so I could ask him to submit more. But I sent my investigator who's had in-person meetings and gone through all the reviews, so I'm just not sure. Besides saying he didn't know,
I get that. We're trying to get to the guy's sense of remorse or anything like that, and without us actually talking to the guy, it's kind of like we don't really know his state of mind.
I would recommend then we could just go straight to formal charges and have a formal hearing.
It sounds like we do know his state of mind, which is he's not remorseful because he doesn't really understand that he did anything wrong.
I think that would be appropriate. Basically, this was not something that we were looking at in terms of the complaint, but when the email documentation was provided supporting the tax return, that's where it became, it was basically just given to us. And I did not counsel him on that during the investigation.
Was it clear from what you saw? If a client says, I choose to refrain from taking a particular deduction, don't take it on my return, to me that's one thing. And the CPA, may or may not know the client's rationale for doing that. But was it clear based on the investigative work or the discussions you had that the CPA, who is the subject of this disciplinary action, knew
Absolutely.
That the purpose was to...
Absolutely,
Okay.
because basically the CPA was provided the expense information, and within the email documentation, it stated, I know I can't take all of these deductions. I have to meet this target of income to be able to qualify for my mortgage loan. And the CPA had actually provided the client with a mortgage lender, so there was no doubt that this tax return would be presented to a lender. Now, as other information that I think is pertinent, that tax return was never forwarded to that lender per the complainant. But the intent was for it to be forwarded.
Is there an obligation that we have to report this to somebody? Like criminal matter or not?
Forward it as to the fraud division of the IRS.
I guess my question is, are we obligated to do that?
Well, but why would... I mean, if I'm the IRS and they didn't take a deduction,
That's up to they don't
then
care.
What difference does that make?
Right. It's
I'm
they
wondering if it's-
benefited from the...
I'm thinking more along the lines of the mortgage lender, but I don't know.
But they're saying it was never used.
never given to so the fraud was never conducted.
Where did the review go?
That's what I'm wondering. It may not
the
go to
review
that.
is to the contractors board.
Oh, this is a contract.
Yeah, one of those.
They were two
classics.
separate clients.
Yeah.
Okay.
And the contractors board, he returned all their money for the review and then paid for a CPA under a peer review to conduct a new review for that client. So they are now fine with contractors board, and they made that client whole.
I'd say you need to up your penalty. I'm not on the committee, but that would be my... I mean, this is pure... If he had the intent to commit fraud,
yeah.
That's what I was going to say, is up the penalty, and then if he does anything else, then there are consequences. Yeah. But this is serious already.
Or he could choose not to pay it and try to come before us and inform a hearing, right?
Correct. This is just an offer for settlement.
Okay. Anybody got a suggestion on how to up the penalty, even the non-committee members? Cough, cough. Trey?
I shouldn't have spoken.
I think it's a fair point. I mean, we're trying to... Yeah, I mean, it's...
I think the first one is pretty straightforward, right? The peer review. And what's our guidelines for where would this fall in our matrix?
I think Sherry has identified two major rule and statute violations, and so you can go up to $1,000. What I have here is the middle of the road first offense. So you could up the $750 to $1,000 and make that one a true $2,000 penalty to ride along with the $3,000.
But in the case of fraud, I mean,
it's per violation per day. So
you have unlimited amounts of
I have to prove
to work with
beyond a, not beyond a reach, but sorry, I have to do a preponderance of the evidence on each of the days that the fraud would have been perpetuated.
Or fraud wasn't actually committed.
It would be intent to defraud, and also I think the strong argument from my perspective is subjugating your judgment to a client. So you're letting a client tell you that they are choosing to not take a deduction for a fraudulent reason, and you're just saying, okay, sure. I'm not going to advise you any further using my specialties at all. So it really is one instance, which is what I struggle with.
Well, I mean, it's not being semantics, but it's not just I'm not going to advise you. It's I'm going to do this in accordance with what you told me to do, and I know it's not right.
I agree, and I would make that argument to a judge and to you all later down the road. But I think I'm just trying to think about how to ratchet up. I guess there's a rule and a statute, so I guess you could say $2,000, one for $1,000 for fraud pursuant to the statute, $1,000 for fraud pursuant to the rule is an option, which would bring you up to $2,000 for the fraud and then an additional $1,000 for failure to gather sufficient data.
You're saying 3,000 total.
So we could do 3,000,
which was what I was going to throw out originally.
Yeah, so that easily and comfortably gets us to $3,000 without even having to.
So it's a total of 6.
Correct.
What are the? Let's explore this notion of a potential suspension. There is a piece of me that says, telling this person to stand down from doing, CPA work is not necessarily a bad idea in this regard. But I would be interested in knowing what additional legal hurdles or burdens that would be placing either on the board or on our legal team and investigative staff?
It wouldn't be any. I don't think it would cause anything additional. If ultimately he could agree to do that, otherwise I'd come before you. And when I do a formal hearing, I'm going to open discipline all the way up and say, if you want to go all the way up to revocation after you hear the facts of today, it's your decision to do so. I may have a recommendation, but ultimately that's on this board or on the ALJ if that were the case. So suspension wouldn't necessarily complicate the process. I think you're going to more likely have a formal hearing, but that might be well within the intent of this board. So,
the problem is I'm not sure what you're going to gain from that at this point, unless you just really want to pull the license. I mean, that would be the.
Yeah.
If your intent is to think that far down and do that, then I would say formal hearing is probably your only option at that point.
It comes down to whether if we end up with a $6,000 in the aggregate fine, we believe that's enough to get his attention. And
Sherry actually makes a good point, which is that the nature of this firm is typically tax. So the suspension of the CPA license actually may have less effect than a financial penalty because they can continue to operate on things.
They still have to have an individual license, would they not? If they use CPA or.
You'd have to stop using that title for the suspension period and just be do tax only. But that would be ultimately what the effect would likely be on that firm, unless he's doing a test work that we didn't locate.
Does the name have the words accounting or anything like that in it that's part of the rule?
It's CPA at the end.
It's an individual's name and CPA.
Right.
So is he no longer going to do a test work?
He claims that they all claim, but he claims that was a one-off scenario for a former client from a previous employment that asked him to do that.
And he's not enrolled in peer review?
Not at this point, no. That's it's part of complaint 1. That's why I require them. You either need to send in the attestation that you're not doing it, or you need to enroll, and that's part of their requirement of the consent order for complaint 1. Hopefully, I put that in here. Yes.
Is there a motion on the floor either to add CPE or to up the penalty on complaint 2 or to do more from anybody?
Well, I would move that we add CPE. I think it's SARS 21 CPE about reviews and, a test work to your recommendation.
How many hours? I would suggest 4 or 8.
Yeah, I think there is a 4 and 8. Yeah, probably, 4 and 8 hour course, yeah.
I think you need to say one or the other. Okay.
And increase the penalty, as you suggested, to in the aggregate $3,000 on complaint 2.
There's a motion. Is there a second?
Second.
All right. Any more discussion? We'll go ahead.
Can I speak if I'm not on this committee in the discussion phase?
Absolutely.
I agree with CPE. I don't know what good the SARS 21 CPE is going to do if he's not performing that work. I guess maybe since he issued one, he should know how to do one. But I just don't. I would lean more towards some sort of ethics issues versus the SARS, because I don't know that the SARS is really going to affect him. Now, maybe it will, because maybe he'll learn that even compilations are involved with that, and I don't know what
that was my reasoning for suggesting that, because that course should cover the difference between compilation, reviews, audits. That's what that course covers. A test. Those
Could
are
we
test
do 4
services.
of each? Maybe four ethics and 4 SARS.
I don't know the ethics course to tell you to take. So, do you have recommendations?
I don't know. Besides the state ethics, I know there's some out there, but as
I
far
agree
as
with her. I think him taking that course twice isn't productive.
Would it be worth?
What about if we did a mandatory CPE audit for his next reporting period? Would that be helpful to make sure he took the state ethics?
I guess my thinking is because this person was doing a review without the appropriate knowledge of what that involves and what the requirements are when you do those. That's why I'm thinking he needs to be educated on those matters.
The only thing that's problematic with that is that it's Tennessee that defines what is a test work, not SARS. And he's so that was my only point, was it's a state requirement that makes it a test work, not the SARS.
Well, I guess I'm just thinking that the SARS is what helps to educate the person on, particularly because they're new requirements. And I mean, you all can help me with this, but that's where those requirements are detailed, is in that SARS 21 education. And to prevent him from doing something in the future that he doesn't know what he's doing, then that's why I think the education would
I
help
agree.
in that
I just feel like
regard.
that's more of a state issue, because the SARS will address that. Here's how you do a review. Here's how you do a compilation. But it's our state rule that mandates that is a test work.
Are those
I don't
state
think
rules,
the SARS actually address
are those
the
state
fact.
rules in a course?
Those are in
Well, in
the state
supposedly in the
specific.
ethics.
Right, but he's already taking that, so
Yeah.
nothing beyond that.
Well, other than just normal ethics, like true ethics.
Right, but there's nothing additional about SARS beyond what's already in the course he's taking.
I don't think he's taking any SARS courses.
No, that's what I'm saying.
You're saying state specific.
State specific.
Right.
Which includes the state requirements for that.
I don't know if he's taken that.
We really don't, but they just attest that they've taken it.
Right.
So that's why you're saying we should do a mandatory CP audit?
That was
Or
something
just
that
at
popped
least-
into my head. He does renew this year.
I don't like
Make
that
sure he
idea.
takes it one way or the other.
Do the audit.
Then if for some reason he did not meet the requirement, he would have to take it.
I'm not on this committee either, but it seems to me like that would be, it's almost like a probation kind of thing. If we're going to monitor, I don't know if we can do it for more than 1 year or whatever, but I think doing that CPE audit for some period of time, just to make sure that he's complying because of his the mistakes he's made, or because it seems as though he's not using due care and he's making these mistakes. Seems to me like we should be able to monitor him for a period of time and make sure he is completing his CPE, because they're just right. I mean, we don't really have a way to make sure that they've done the CPE they say they have done, right? Isn't that right? I mean, we do some testing for whether or not of the whole group, but not specific individuals. I would anyone who's making these kind of decisions, seems to me that having them audited for a certain period of time is fair. I don't know if that's against any rules or anything else. That's just my 2 cents, and I'm not even on the committee.
So we've got a motion and a second for amending the penalty suggestion for complaint to an aggregate penalty of $3,000 and 8 CPE hours of SARS 21 training. Do we want to amend it with anything?
Well, we could amend it to add a CPE audit. I'm not sure what would the time frame be, Wendy? What could it be?
He renews on 12/31/17, so it would be in my suggestion would be an audit for the 16-17 reporting period.
Supportive of that. If you'd like to make that amendment, I would second that amendment.
I will make that amendment to include a CPE audit for the period ending 2017.
All right. Any more discussion? So let's go ahead and vote on number 15. So I guess I'm sorry, we got to vote on the amendment to complaint too. So, all those in favor of the amendment presented by Janet, I'll say aye. Aye. All those opposed?
Steven's not on this committee, so I think we're okay.
All right, so that passed. So let's do real quick, just finish 15. So, because there's two, we have to vote on it as a whole. Is that right or not?
Vote on it as a whole if you'd like to.
Okay, so all those in favor of the penalty recommendations for complaint 1 and complaint 2 as amended, say aye.
Aye.
All those opposed? Okay. 16.
Number 16, this is a matter where a review was sent to staff again by the Licensing Contractors Board. The respondent who conducted the review is not licensed. Respondent responded to say that he is an enrolled agent and he's not required to hold a CPA license to prepare financial statements. He contended that the submitted document was only a financial statement and not a review. I've had Sherry review this just to be sure, since there was a fairly adamant response to this document, and Sherry found multiple instances where not only was this a review, but possibly bordered on an audit, just because of the amount of work put into the details of and the amount of checks being done and documentation outside of the review being looked at. For example, it specifically says on there, this is a balance sheet of reviewed financial information provided to me by the client based upon a review and does not represent audited financials. However, Sherry noted that some of the review procedures and audit procedures were applied, that SARS 21 seemed to have been implicated as far as the process being involved. Including obtaining documentation to support balances from third-party property assessors and phone conversations with the bank, which Sherry noted are actually audit procedures, not even review procedures. In addition to this, respondent's headings list his title as enrolled agent and public accountant. Respondent is not a licensed public accountant in this state or in any state. For that reason, I requested a $2,000 penalty of $1,000 for conducting a review while being unlicensed, and the second for the unlicensed use of the title public accountant.
So, just remind me, public accountant is specifically in the statute. This is you can't use it.
Yes, it's specifically.
What is a public accountant?
Is
it a CPA? Or not?
I apologize.
I don't know. It was grandfathered out many years ago. We have, I think, 10 to 12 PAs still remaining.
Okay. Okay. And is this language that he included in this letter, please find attached a balance sheet of reviewed financial information sufficient to satisfy that it was I don't know that it was a review, but the fact that it had to be a review for the licensing board.
Well, the licensing board has the requirements, and not only that, I think he issued a cash basis statement. I think you have to do that on GAAP financials too. So it was not correct either way.
That's true. I was going to say, I think, and Wendy, you might help me with this, but I think that basically, as being an unlicensed accountant, he is limited to safe harbor language in any type of report. So to have something that simulates a review report, like saying, please find a balance sheet of reviewed financial statements, information provided to me by. There was a second reference in a note that said the financial statement is based upon a review and does not represent audited financials. And then there was a third statement that said reviewed by the respondent's name with the EA number afterwards. So there was a specific statement on the face of the financial statement that it was reviewed by the respondent.
Agent can't do that? I don't know. I'm asking.
I think it's clearly unlicensed activity. It's given the appearance.
I don't think
expertise as an accountant, and that he has reviewed a financial statement.
In Rule 0020-04-0 or .06, under the safe harbor language, 2 says The use of standard language in any report as defined in Tennessee Code Annotated 62-1-103 by non-licensed individual or non-permanented firm, even if the verbiage is slightly altered, would be considered a violation.
All right. Any other questions about this or recommendations on it? Okay.
You don't mention peer review. I'm just curious why, if they did the review.
Not licensed, so.
Oh, they're not licensed. Okay.
Yeah.
Does there need to be anything in here with the consent? Do we need to give you the authority to put in the consent order, assuming the person responds to you that they will stop doing this and they will quit using public accountant definition or title?
Using cease and desist language in the consent order is acceptable. Actually issuing a cease and desist, I'm not sure. This is a debate I've had with deputy counsel. We actually have any authority to do a formal cease and desist, but I can include cease and desist language in my consent order, assuming he consents to it. So I can't send out a cease and desist letter all on my own, but I can have them agree to it in a consent order, yes.
Okay. All right. Any other questions on 16?
Discussion that we talked about the fact that he had gone beyond what is required for a review and actually did some audit procedures, because wrong with him doing audit procedures as long as he doesn't report that he did an audit. So, I mean, is there some particular reason that that's in here?
From my perspective, it was just, and this was included in his response, specifically stating what he did to provide a level of assurance in terms of what he was doing. To me, it just provides further evidence that this was not just a financial statement, that some attest work was done in conjunction of preparing this financial statement. It wasn't just a printout out of QuickBooks. There was attestation procedures provided, whether they were audit or review, but that just provided further evidence that this was not just a financial statement. But I agree with you that he could do audit procedures in a review, and that's fine. Exactly. Yeah.
Attorneys later.
Yeah. You see.
Okay. Anything else on 16 before we go 17? Okay, let's go 17.
17 was a CPE audit with a failure to respond to that audit. When the complaint was open, respondent did respond and stated that he couldn't find the paperwork to submit, that he lived, and quote, a busy life with a lot of travel and a lot of staff. He requested to go inactive and stated he attempted to handle it over the phone, it being going inactive, but was advised it was not possible. Respondent did request to go inactive didn't respond until well after the CPE and the whole audit was due. So I don't really usually take that into consideration. And for that reason, I've requested the typical $1,000 penalty, 120 hours to be submitted, and that those cannot be used for anything but penalty.
Any questions? Busy life. Man, I wonder what those are like. Number 18.
This one again is a CPE deficiency from an audit for not responding. The respondent did respond to the complaint and stated that he did not complete the CPE and that he has not used his license professionally and requested to go inactive. And again, they did not request till well after CPE was due, so the typical recommendation is there for your consideration.
Questions? All right, let's go 19.
This is another CPE audit with a failure to respond to the original CPE notice. They did respond to the complaint and stated that he had attempted to set it as inactive when he renewed at the end of 2016. The respondent stated he did not know he needed to submit any additional documentation. Upon receiving the complaint, he did submit proper documentation and his license is now inactive. Respondent previously had his license set as inactive, but it was reactivated in January 2015. I reviewed all the renewal applications. So the renewal application was actually dated 4/5/2017. Respondent in that renewal said no to the question whether his license was set as active. And I mean, maybe that's where he tried to go inactive. That was my guess. But regardless, his license was active from 1/8/2015 till 8/17/2017. So even if respondent intended to set his license back as inactive when he renewed, his renewal was dated after the CP audit cycle, and therefore he owes, again, the typical recommendation for this failure.
Questions? All right, let's go 20.
That's 2017025791. This complaint originated from the Board of Licensing Contractors after a review report was provided to them by the respondent. The respondent was not enrolled in an approved peer review program, and the most recent firm renewal indicated that the respondent does not offer attest services. He provided a response and stated that this was his first review performed and the respondent would sign up for peer review upon renewal of the firm license. My recommendation is to authorize a formal hearing and assess a civil penalty of $3,000 for failure to enroll in the peer review.
Questions on this? Okay, thank you. Let's go to 21, 22.
21 and 22 are companion cases. 2017020781 and 2017035951. This also originated from the Board of Licensing Contractors after an audit was provided to them prepared by the respondents. The respondent holds a valid CPA license. However, respondent 2, the respondent firm that employed the first respondent, did not hold a registered firm permit. None of the parties were enrolled in an approved peer review program. According to Respondent 1, the respondent was employed by Respondent 2 and was asked to verify a client bank account, and thereafter the Respondent 2 requested Respondent 1 sign an audit report confirming the existence of the bank account. According to Respondent 1, the Respondent 2 prepared the audit and brought it to Respondent 1 with a balance sheet and a bank account detail to the Respondent's office and asked the Respondent to sign it. Respondent 2 provided a response and stated that he had double-checked with Respondent 1 if there was any problem with Respondent 1 signing the audited financial statement, and Respondent 1 stated there was no problem. Following an investigation, there were additional violations discovered against Respondent 1 that were outside the scope of the investigation request. However, they were reported in the investigation. Respondent 1 was operating a CPA firm without a permit. The firm was not opened until after that Respondent 1 had left the employ of Respondent 2, and Respondent 1 did not issue an audit under the new firm name. The audit was issued in the capacity of as an employee of Respondent 2. The Respondent 1 was operating as a sole proprietor and is required to obtain a firm permit in Tennessee. So my recommendation here as to Respondent 1 is to authorize a formal hearing for $1,000 for not having a firm permit and a letter of warning for failure to change employer and email address in a timely manner in violation of the rule. And for Respondent 2, authorize a formal hearing and assess civil penalties in the amount of $3,000 for providing attest services to a client without having an active firm permit in violation of the statute and using report language reserved for use of licensees because he held out using the title or designation of accountant. He referred to himself as a federally licensed tax accountant.
There's such a thing as a federally licensed tax accountant?
Title he's made up to sound official.
Federally licensed lawyer. So was there a failure to be enrolled in peer review penalty too, or not?
I don't believe so, no.
No, ultimately, Respondent 2 is not licensed and cannot be licensed as a firm.
Didn't we do something earlier where somebody wasn't licensed, but we got them for not being enrolled in peer review? Or am I forgetting?
I think if the Respondent 2 was able to be licensed, then I would agree. But this respondent cannot be licensed. Person's not a CPA.
So should we assess a $3,000 penalty to that person? Make it the same financial penalty as somebody who could be but isn't? I mean, I don't want there to be an inequitable penalty applied to people who are licensed properly and just didn't enroll versus those who are doing the same bad action, but we can't technically force them to get enrolled in peer review because they're not eligible because they aren't CPAs. Does that make sense?
Are you suggesting to reduce it?
I'm suggesting to add another $3,000 to it to treat them like people who could be enrolled in peer review but aren't.
The respondent 2 was a firm. The complaint is against the firm.
What I'm saying is if the firm was owned by a CPA and could be enrolled in peer review, then we would have tagged $3,000 onto them like we had everybody else, right? Because they weren't enrolled in peer review but issued in a test report.
Correct. And in this situation, the firm is not owned by a CPA, cannot have a firm permit, therefore can't enroll in peer review, and can't do test work for that matter.
Well, I guess what I'm saying, though, is from a financial perspective, we're penalizing people who can be enrolled in peer review more than we are people who can't be for this same thing, right? Because by not giving it...
I think it's mainly because those people, we expect that they should know the law and the rule. Because they'd have to be licensed. And this individual claimed that they didn't know they couldn't do the work and didn't know anything about peer review or...
I don't see how we can hold them accountable for peer review if they can't have a peer review.
I'm not suggesting we do. I'm suggesting we make the financial penalty be the same.
It's not fair that they...
But, I mean, maybe not. Maybe we hold people who are licensees to a higher standard.
So you're saying the penalty would be $6,000 instead of $3,000?
Yeah.
I guess I was looking at the penalty of $3,000 being equal to what it would be if it was a licensed person.
It helps to clarify these respondents no longer have any relationship to each other. Yeah, so 2 separate entities that have no co-ownership between them. So if it wouldn't be a conglomerate, it would be one person getting a penalty over here in their new life and then the firm getting a penalty completely separate from each other.
Right. Okay. And so respondent 2, they're the one who issued the report and is an unlicensed.
That's a correct statement.
I was going to say the Board of Contractors received 3 reports for this particular engagement. The first report was a review report that was signed by the owner of Respondent 2 firm, with Respondent 2 firm listed below. Okay. The second submission was, interestingly enough, an audit report instead of a review report, signed by Respondent 1 as an employee of the firm Respondent 2. And then the third submission they got was from another CPA firm that was properly licensed.
I'm trying to keep myself from going off base, and I may be getting there, so just tell me if I'm wrong. So if Respondent 2 was capable of being a licensed firm, I understand that we're speaking hypotheticals, but if they were capable of being a licensed firm and they had provided a review report to the Board of Licensing Contractors without being enrolled in peer review and had done everything else, would it be true that we would be giving 4 penalties associated with 4 things? One is providing a test server to a client without an active firm permit, using a report language reserved for licensees, and using this weird designation as a federal licensed tax accountant. And we'd be dinging them for not being enrolled in peer review. Is that true?
Yes. Those would all be viable violations for someone who holds a license.
I guess for the committee, for you to decide, because I'm just throwing it out there. My only comment is we would treat someone who is capable of being licensed or a licensee who's not enrolled in peer review that way. And here's somebody who's not capable of being a license and doing the same thing. We're letting them off with a different, lesser financial penalty. And my question is, are we okay with that?
Not sure I would describe it as letting them off, at least in my view. I mean, to me, the first violation for Respondent 2 is they're not a licensed firm. They shouldn't have been doing what they were doing. proposing, I guess, to fine them, in this case, $3,000, which to me is equivalent what we would fine a licensed firm that was not enrolled in peer review. Not sure I would insist that we have to pile on and say, well, but hypothetically, if you were, we would consider an additional fine. I think intellectually I get that point. I'm just not sure practically that I'm willing to kind of go that far on this one.
My response is I think we're only penalizing them $1,000 for that. We're not penalizing them $3,000 because there's three different things we're penalizing them for $3,000. And I would think, though it doesn't say this, that it's reasonable to conclude that that's $1,000 a piece. So we're talking about 1,000 versus 3,000 then.
Just out of curiosity, I thought we've had this before where, I mean, there is not a CPA there, correct? And
there was one CPA there at the time that was an employee.
Okay.
Not a partner, not an owner of the firm.
And so do we as a board, I mean, I would love to fine them for that, but do we as a board have any jurisdiction over people who are a firm that is not eligible to be a CPA firm? Unlicensed. Okay. So we can.
Breaking Tennessee state law.
Okay. Yeah. Okay. Good.
Okay. So,
just checking. I know
so Gabe, your question was, why wouldn't we assess fines of $3,000 plus maybe another $1,000 for the undesignated title, and then another $1,000 for using an inappropriate title? So say 5,000 instead of, or 6. Yeah.
No, I would say 5,000 instead of 3.
Yeah.
It's kind of, I mean, I understand what Kevin's saying, and I'm okay with it. I'm just throwing it out there.
I could see your point there.
Your point being is reasonable. These people should not have been doing what the respondent number 2 should not have been doing what it did in this case, and they messed up in a variety of ways. But I also see this mess up as kind of, I guess what gets me back to the 3,000 maybe being adequate as a proposed remedy here is that all of these violations centered around the one instance where, you know, they issued an inappropriate, they were maintaining that they were licensed and did not have the appropriate authority to do what they did.
Just to let y'all know, I looked, and apparently this federally licensed tax accountant is pretty common for an enrolled agent to use that in their they are. That's what I'm saying. I mean,
I don't think this is the first time I've ever heard that. I mean,
yeah. I just looked up online, and it's a term that that a number of enrolled agents are using. So we might need to be aware of that. And they shouldn't in Tennessee because they're using the word accountant in the first place. But that's something we might want to look for.
Let me just say, I don't have a problem with the $3,000 penalty, Gabe. I mean, I think that's okay. To me, the more important thing is that we let this individual know they should not be using the title federally licensed tax accountant. I would assume that's language that can be incorporated or will be incorporated in the consent order, so that they clearly understand that being an enrolled agent or whatever doesn't give them the authority to use this kind of language. That if they do, they're going to be in violation of.
Yes, that language will be included in the consent order.
Can I go back to Gabe's point about, I guess it's disparate treatment of licensed versus unlicensed individuals? And I guess I'm not sure as far as unlicensed individuals go. I mean, do we have the authority to penalize them the same as we would a licensed individual? Or what's been our practice on that?
For unlicensed activity, yes, and these other violations, that I mean, they're specifically set out that they are violations. You can't hold yourself out as a federally licensed tax accountant.
And so are we at risk of being, I guess, inequitable with how we treat licensed versus unlicensed firms or individuals?
Well, we have authority over, per the statute, over licensees more so than an unlicensed, but the statute specifically references unlicensed individuals as well as using various terms representing yourself as an accountant or CPA.
But the real issue is that perhaps the fines are relatively low for the non-licensed activity in comparison to the fine against the licensed firm that's not having peer review. I still don't think we can find someone who couldn't even have peer review. I don't think we can find them for not having peer review. I am sympathetic to the idea that the fines are relatively low, and I don't know if there's another justification for increasing those. But I don't think it can be tied to peer review.
Well, again, I was never suggesting that it was. I'm just saying that you do.
But that was the rationale.
It was the rationale, but it would just be tied to one of these other things.
Make it equitable.
Yeah.
Yeah.
And I guess I would go back to Wendy's original comment that, part of the rationale, at least in theory, might be that a layperson or someone who's not a licensed, not in a position to necessarily know what they're violating. And in this case, they had multiple violations in one episode, I guess we'll call it that way. It's almost like in baseball having 3 errors on one at bat. And I'm not sure I'm terribly keen to rack up, assessments on each error. I mean, I think we're going to be able to clearly say with a $3,000 proposed, remedy here that you messed up and you better not do that again. And does that point get made, significantly more efficaciously if we up 5,000 or 6,000? I'm not sure in this case, given that it's an unlicensed respondent, that it would. That's what I'm torn about.
And I buy that. I mean, it's at the end of the day, it's $3,000. This is what we would do against someone who was licensed but not enrolled in peer review, and so on its face, it's equitable.
Maybe it is appropriate to fine CPAs more heavily because they are holding themselves out to be higher level professionals.
Any more discussion on that? Okay. So let's go to 23.
2017-019-511. This complaint was received by the complainant, and it was an account that provides accounting and bookkeeping services for several nonprofit and small businesses. The complainant had 4 clients or potential clients where it appeared that the respondent had created corporations to function as tax loopholes. The complainant alleges that the respondent provided erroneous tax advice, filed incorrect tax returns, neglected to inform the clients of other state and local tax liabilities. The respondent provided a response and stated the respondent provided all information to allow the clients to make decisions on the type of corporate status. The respondent always provided the clients with all documents and their QuickBooks electronic files. An investigation was conducted, and the board investigator stated that the respondent did provide erroneous advice regarding business formation. The respondent, the allegation that the respondent provided erroneous advice regarding business forms are without merit, but there was also no evidence supporting the claim that the respondent failed to inform her clients of other state and local tax liabilities, but the investigator did find evidence supporting dishonesty, fraud, gross negligence in the performance of tax services by the respondent. A review of one of the respondent's former clients' returns yielded variances between the tax return filed and the accounting records supporting that return. My recommendation is to authorize a formal hearing and to assess civil penalty in the amount of $2,000 for violations of the Tennessee Accountancy Act, specifically dishonesty, fraud, gross negligence, performance of services.
Questions? last one we had with this, we had a lot of discussion around the fraud, but we didn't amend the penalty recommendation to address that other than to do the mandatory CPE audit to ensure the person went through the state-specific ethics. Right?
What were the specific instances of the fraudulent? You're saying they were putting in made-up deductions? Is that?
Sure.
Just so I'm aware of.
Basically, I was fortunate enough to be able to speak to one of the former clients that the complainant was working with that had previously worked with the respondent. She was also willing to share her experience with the respondent as well as her tax return and her QuickBook records. Reviewing through that, some of the specifics were, and keep in mind this business was a small business with revenues of about $51,000 is all, very small business. There were advertising expenses of $5,300 that could not be supported, and the client could not explain why they were on the tax return. Said the respondent, when she asked the respondent, I'll get to that later, but that was one. There was no documentation for the mileage deduction. That was, she deducted mileage on 23,000 miles approximately. The client said she did have some miles, but she didn't have any documentation of it. There was an $8,600 1099 contract work on the tax return that the client could not explain. And there was also a little over $8,000 in printing costs, which, given the client's business, it would seem reasonable that they would have printing costs, but there was no documentation for those deductions, and the client was unaware of why those deductions was taking. Now, she asked the respondent specifically about these particular, variances between the accounting records and her tax return. The respondent's response to the client, per the client, was that I have a lot of experience. The respondent has worked with the IRS in the past for 10 years. And the response to the client was, I have a great deal of experience in this, and I know what the IRS will accept and what they will not accept.
She just made up, or this individual made up.
Potentially. I'm not going to say that she made them up, but the evidence leans in that direction because the client is unaware of what those expenses were, and there was no documentation of those expenses.
And you had the QuickBooks that was used.
I had the QuickBooks file, yes.
The respondent, did you confront the respondent with those allegations from the former client, and did the respondent
Excuse me, can you repeat?
Did the respondent hear what the former client said and offer an alternative version of the story?
I did not follow up with the respondent regarding the allegations. So, as I said, he or she may have reasons for that, but they are not documented.
I would be careful. I think
I'm getting a little nervous on that one.
One side of the story on that one. Not saying that that's not true. I would be really careful on that because I think we'd be treading in some pretty dangerous waters to do that at this point. I mean, if we're going to do that, we can do it, but I think we need to have them here and let the person be confronted and offer their side of the story as well.
We do have sworn statements, though, for whatever that's worth.
From the respondent or from the claimant?
From the client.
The former client or the one that?
The former client,
okay.
Yes.
We can get into he said, she said all day long, and then that
sounds like there's enough here for the actual claimant and respondent before we get into the former client stuff. It's my opinion. So again, the last one we had with fraud, we didn't really address other than the mandatory CPE audit. Do we want to do anything different here or add to this at all or not?
Just to kind of review the bidding here, make sure I understand the nature here. So we had an original complaint that was investigated, and I guess the allegations in that original complaint were deemed not to be founded.
Basically, there were 3 issues identified in the complaint. The first being that erroneous tax advice had been given in terms of corporate form. I role-played with the respondent in regards to that, and I saw nothing that would indicate to me that there would have been any erroneous advice provided. Obviously, the client has some responsibility as well because there's pluses and minuses to each type of corporate form from a tax perspective and otherwise. There were some allegations of state taxes and business taxes that weren't paid, but there was no proof of that. And then obviously the other issue was that there were questions on tax returns that were not addressed by the respondent to the client.
But I guess my point is if we're not certain that these are not legitimate deductions, without the respondent replying, I don't understand what we're.
I don't think I would not be comfortable assessing penalties based on what a former client said, because they're not the claimant. It wasn't part of the formal. In fact, I'm going to move, just as an FYI, to strike everything in the report related to the former client. But in terms of the original, the claim from the claimant to the respondent, that's what we need to figure out. And if we think there's something there on the former client, we can open a separate. I think y'all could probably institute your own claim and look into that respondent former client relationship. But just based on, I mean, this is technically hearsay, but based on this one-sided story, I don't think we can do anything on. I would not feel comfortable doing anything on that.
The reason we didn't follow up with the respondent on that because that wasn't part of the original complaint. Is that?
I'm going to let Shalina address that.
That was not part of the original complaint.
We put it in here, which makes me think I don't understand how we get to here and not do a thorough follow-up on that.
There was a violation. A violation was found.
What was the violation?
The violation was that there was variances in the tax return. There wasn't any substantiation.
But you haven't talked to the respondent, so you don't know whether that's legitimate or not. That's what we're saying.
No, it was just based on the investigation and her review of all the documents.
It wasn't reviewed.
It was not reviewed from the respondent's perspective.
Yeah.
There are always differences. There can always be difference between tax and financial statements. I mean, there are different depreciation methods. There are different things. I mean, there are reasons why there could be differences. We have not thoroughly investigated that claim because we haven't talked to the person that signed that return.
Right.
I could add one point, if I don't mean to interrupt, but one point that I noticed that I did not add that added an additional level of maybe suspicion related to the company tax return that we looked at was when you looked at the company tax return, the end result was exactly $0 of taxable income, meaning deductions exactly equaled revenues on the corporate tax return.
And again, you can only take Section 179 expense to the extent that you have income, right? So my point is that you have no idea without talking to the respondent whether or not he has substantiation, or he or she. I don't know if this is.
And that's my question. Why did we not take it one step further and just talk to the respondent and say,
what's going on?
Yeah. Why did we stop just finding differences that we couldn't explain?
I don't understand how we get to here. We're about to assess penalties, and we have not fully investigated that. That's my point.
I'm not sure, and I don't want to misspeak. I thought we talked about this, and this was more of a legal issue to not discuss with the respondent, but I don't want to.
I would think you would always talk to the respondent. If I'm being accused of something and my license is at stake, you would talk to me.
Right.
I mean, that's
a dangerous game.
Very dangerous.
I guess my question, too, is that if we looked into the complaint and we were like, well, there's no evidence to support the complaint, it seems like the proper thing to do is to close that out and then open a new one with respect to the former client and the respondent and then investigate it as if we're going to investigate it fully. I mean, we can't start, I don't think.
Makes sense to me.
It would be wise for us to go
I'm
down
not
this road.
disputing. I'm just saying that at the time it was my understanding that we did not want to pursue further with the respondent on that. And I'm a CPA. I'm not an attorney.
So I will tell you, this is my opinion, and as a voting member of this board, I would tell you that if we're going to show up here with some sort of recommendation of penalty or revocation of license, you can't do that without talking to all parties involved. Now, if that party refuses to talk to you, that's a whole different story.
Right.
But we'll have to move forward from that point and deal with what we're doing. But I mean, we're acting as judge, jury, and executioner here without even doing the full-born. I'm saying I'm very frustrated with this issue right now because I think that's.
Yeah, I agree.
I don't understand this.
And I'm concerned about this paragraph where it says the investigator did find evidence supporting dishonesty, fraud, or gross negligence. I'm not sure that should be.
I'm already going to move distract all of that.
That's where I was headed.
I guess my question is, this is probably something we need to run up the flagpole with C&I Legal. Is I don't ever recall seeing. I'm not saying it never happened, but I don't ever recall in the 5.5 years I've been here seeing a complaint where we investigated it and there was nothing supporting those complaints, and then we shifted to a different complaint. I think apart from a substantive issue, you probably got a procedural issue. So I think what we need to do is figure out from C&I in that situation, is it proper to just then let the investigation morph into someone else, or do we close the original one and open a new one related to the new people? I know we're investigating the respondent, but it's based on allegations and a claim, and if those have been investigated and found to be baseless, or at least not evidence supporting them, it seems to me like we'd be much better legal position to close that and open a new one with what you did find. But that's not my decision, that's C&I's decision.
We do it actually both ways. We have investigations where it'll be under one complaint and we find new allegations and they just continue to live under the same complaint number, because ultimately the complaint can be opened in any way that we want, by board, by staff, by a person. Sometimes for cleanliness, if there's really the only time I open an additional complaint is usually if it's because it's a new respondent, not necessarily a new complainant, so that way it can track to the entity. We're kind of under. Really, it comes down to what it is administratively convenient now that we have a new centralized complaint board. If we were to send it for a response or anything like that, it could still all exist under one complaint number. It's not actually, our complainants really are just victims, and we are actually the complainants. Right. So ultimately, they can't exist under one complaint number. But every attorney is going to treat that differently, because I don't believe we have like a specific SOP on when that has to occur.
And that's fine. That's not my decision to make. The point is, if we looked at the complaint and we didn't find anything and we have suspicions, I think in the future we need to investigate those suspicions like we would anything else before we bring them. And if that being the case, can I make a motion as the chair of a committee or not? I would motion that on this one, that first of all, we strike the last paragraph from this report. And then I don't know how to word my recommended action, but my recommendation would be to continue to investigate whatever you have suspicions of and represent it sometime in the future. I'm not quite sure how we word that
motion,
but whatever that is, that's the spirit of it.
What I can do is I can pull this particular matter from the legal report and represent it to you at the next meeting with the additional information.
I need to make that as my motion then. Just to pull it and have you represent it after further investigation?
Sure.
Okay, so my amended motion is to pull number 23 from this legal report and then have them represent it to us at the point in time when they have completed further investigation.
Yeah, and just to follow up on that, and I do second that motion, but even if we left it in there, with having just one side of the story, it should have said potential dishonesty, fraud, or this is a matter of, it says right now that we found evidence supporting that, but we only had one side of the story. So I'll second your motion.
Yeah, and the reason why I think we all care about that is that potentially somebody could pick this document up and read it and say, well, why didn't they do something if they have evidence of it?
Exactly, yeah.
Or this guy could say we defamed him.
Yes.
Yeah, that's the other part of it.
I think it's anonymous, but you're right. Yeah. I mean, you could. Okay, so motion second. Any further discussion? Okay, all those in favor of the amended approach, number 23, say aye.
Aye.
Aye. All those opposed? All right, let's go to 24.
Number 24, 2017029821. This complaint originated from the Board of Licensing Contractors, who's provided an audit prepared by the respondent. The respondent holds a valid CPA license in Tennessee, however, does not hold a valid registered firm permit. The respondent is also not enrolled in an approved peer review program. The respondent provided a response and stated the respondent transferred his CPA license from another state and assumed a firm permit would be issued. The respondent admits to preparing the audit report. My recommendation is to authorize a formal hearing and assess a civil penalty in the amount of $4,000 for failure to enroll in peer review.
My question on this is, we've done 3,000 in the past. I feel like on a lot of these, was there an extenuating circumstance that put us to 4?
I question this too, and I think it's just the way it's worded. I think there were 2 violations. Help me, Shalini, here. I think it was that he didn't have a firm permit for 1,000 and then 3,000 for the peer review part.
Yes, that's correct. That should be revised to include the unlicensed firm. Did not hold a valid registered firm permit.
Right. So I'm sorry that I'm prolonging this, but I've got to understand this. So we just talked a little while ago about somebody who wasn't a licensed firm and wasn't enrolled in peer review, and we only did $3,000. And now we have the same issue. The only difference is that this person can be enrolled in peer review and can be licensed as a firm, right? And it's $4,000. So I just need to understand the difference, because I thought what our point was is that we
This
wouldn't.
individual is a.
I mean, this is the hypothetical that I proposed, and we said in that situation, I thought we said that $3,000 is what we would do. We wouldn't be piling on.
There's a violation of peer review here, and there wasn't that violation necessarily in the previous one.
Only because factually legally they couldn't qualify for peer review.
And legally, how do we hold them accountable for that?
Again, not holding them accountable for peer review, punishing them the same financially. So increasing, because $1,000 per day per violation, we could go to anything we wanted to do. So my whole point was, do we make it the same money, even though it's got a different basis?
So we have equity of treatment.
It just seems like we're kind of all over we're ping-ponging back and forth on this. And maybe that's what we want to do, because we're talking about licensed people and we hold them to Pamela's earlier point. Maybe that's legitimate. I mean, it is legitimate, but maybe that's what we want to do, is we hold licensees to a higher level.
Maybe I'm confused, because I thought we were doing the $3,000 on like a first offense for failure to be enrolled in peer review.
Right.
Totally. Here you got 2 violations. Here you got a CPA that is practicing as a firm without a firm permit. And that's one fine. Mm-hmm. And then he should have been enrolled in peer review, and that's...
I agree. But what I'm saying is, I made that point 20 minutes ago, and I thought we had said we wouldn't be piling on in a situation like this, whether they were licensed or unlicensed. But maybe I misheard.
I think from my perspective, but I guess one of the distinctions in my mind was in this case we have a CPA who apparently is an individual CPA, but who, for reasons as explained improperly, did not get a firm permit. So we're going to fine him for that. And in the other case, the respondent 2 was, we didn't have a CPA in play in respondent 2, and we didn't have a licensed firm or a licensable firm in play in respondent 2 in that other case. So I'm not bent out of shape over where we've landed here with 4,000. And I still think we need to kind of hold the CPA to a greater degree of accountability, because this person should have known that she or he needed a firm permit to do what they were doing.
And I'm okay with that. I just want to make sure we're articulating what our committee's policy position is. And the policy position is that if you are a licensee, right, or someone who can be a licensee, I guess, we're holding you to a higher standard than someone who can't. And I'm okay with that. I just want to make sure, because this is going to happen again, and I don't want this to happen again and we ding that person for $3,000, because then our committee is failing at our job of being consistent, in my opinion. So I guess I'm making sure the committee as a whole is comfortable with this approach, that if you're a licensee, you're held to a higher standard. I'm okay with that. I have multiple professional licenses and I'm held to a higher standard. But let's just remember this conversation so that in the future, it's $3,000 for failure to enroll in peer review, and it's potentially another $1,000 for another related but distinct violation. I'm okay with that, but that's what we're doing, in my opinion, by making this vote, and we're making a policy decision that I think we need to continue to honor going forward. Are we okay with that as a committee?
Well, I mean, I don't know that it's just the committee. I think it's the whole board needs to be comfortable with that, because I agree with you. We are in effect, making a policy decision that that's how we're gonna behave.
I don't know. Maybe I'm just dense, but I see them as different. I mean, in this case, you got an individual that is licensed. He just didn't get a firm permit. In the other case, the individual was totally unlicensed to do what he did.
Well, the CPA was licensed. There was a licensed CPA, right? The employee.
The $3,000.
Yeah, but that was a separate violation, a separate penalty.
And he was a totally unlicensed individual doing unlicensed activity, and I see them as entirely different situations. I mean,
my understanding from legal, though, is unlicensed. There was 2 or 3. There were multiple unlicensed activity violations, and you can ding them under our rules penalties for that. And what we decided to do was say we're going to do $3,000 for the whole gamut. And in here, we're saying we're going to individualize and look at everything that the licensee has done and ding them individually. Again, I'm okay with that, but that's, to me, that's a substantive nuance. We're not piling on in one issue, and we kind of are piling on in another issue. I don't disagree with that. I'm just saying I'm trying to articulate my.
Where are we piling on? I don't.
Because we're individually, we're saying you have a violation here and here and here as a licensee, unlicensee. This unlicensed practice, which is completely distinct from this unlicensed practice, which is different from this unlicensed practice. But we're going to look at the unlicensed practice as a whole and say it's this. And for you as a licensee, we're going to get you for this and for this and for this.
Did we not break that down?
Yeah, it was broken down into 3 separate violations in the other one.
But I think what Gabe is saying is that in effect, we will fine licensed firms, individuals more than we will unlicensed firms or individuals. And we're just saying, is this the policy that this board wants to enforce?
No, I mean, that's my point. We want to hold them to a higher level. I'm okay doing that.
And I could be okay with that too, but I think we need to be conscious about what we're doing. And in effect, that would be what we're doing is unequal treatment.
Can we put to rest the idea that the other one was not separate charges? I mean, separate fines. They weren't they?
They were separate.
For
3 separate, $1,000 for each violation.
So the way I see this one is, if you had a firm if you had an organization that did not get a firm permit, that's 1 fine. As long as they had peer review, they'd only have that 1 fine. However, here we have someone with that fine and they didn't get a peer review. I see it as 2 separate things. So I think
policy decision we're making, but anyway.
I'm not without sympathy for the policy decision, but I still think we reserve the right as a board to listen to the individual facts and circumstances and make collectively as a board our best determination in a disciplinary matter. And let's strive for consistency. And we just may be having apples and oranges as between an unlicensed situation and a licensed situation. So I don't think we're that far out of tune.
I'd be okay with raising the fines for the unlicensed activity. I think looking at the peer review fine as something to compare to would also be like looking at no CPE and those fines as something where we'd need to bring them up to that level as well. But no, if we're saying that the unlicensed fines are too low, I think that's something we could look at.
Okay, so you have a discussion on 24? Okay. 25.
2017-034-161. This complaint also originated from the Board of Licensing Contract, who was provided a compilation report prepared by the respondent. Respondent was not enrolled in an approved peer review program. The last renewal submission to the board indicated that the respondent firm did not provide attest services. The respondent provided a response and stated they did not provide attest services. Additionally, information provided by the board office reveals the respondent had completed a compilation report in 2015. Following an investigation, it was concluded that the respondent issued 2 compilation reports, one in 2015 and another in 2017, without being enrolled in a peer review program. My recommendation is to authorize a formal hearing and assess a penalty in the amount of $3,000 for failure to enroll in peer review.
Questions or follow up on this? All right.
26-2017-046721. The respondent was selected for an audit for the 2015-2016 CPE reporting period. The respondent failed to respond to the audit after multiple communications were sent to the respondent. The board office finally received a response, and the respondent indicated that the respondent was attempting to research this matter to try to remedy the situation and could not find a remedy. The respondent has not reported the CPE hours, and the respondent has not provided any further information since July 20th, 2017. Upon investigation, it was discovered the respondent was compliant with the total hour and technical hour requirement for the previous reporting period of 2013 and 2014. However, the respondent was not compliant with the state-specific ethics requirements. The respondent failed to respond to the CPE audit and admitted that CPE requirements were not met for the 2015-2016 reporting period. The respondent still needs to complete an additional 52 hours of CPE and at least 4 hours of state-specific ethics courses. My recommendation is to authorize a formal hearing and assess a civil penalty in the amount of $1,000 and a requirement for completion of 52 CPE hours, with 4 of those being the state-specific ethics courses within 180 days after execution of the consent order.
Questions?
I want to add the wording that we've used in the other ones, that this, if the committee wishes, that these hours would be considered penalty hours and could not be used for renewal.
I want to make a motion to that end.
So moved.
Second.
Second.
All right, any further discussion?
Can I ask a question? Yeah. The wording is confusing to me, where we say the respondent requirements were not met for 15 and 16, but then we say the respondent was awarded 52 hours for 15, 16, and that wasn't enough.
Yes, I believe there was a deficiency still.
Hours, it wasn't enough.
I believe so, yes.
So you're saying, okay, it's a 2-year period. Okay, I'm sorry. I wasn't thinking of 2 years. Okay.
All those in favor of adding the amendment to the recommendation of these hours not being penalty hours and not counting towards future compliance periods, say aye. Aye. All those opposed? All right. And then number 27.
2017-048081. The respondent was selected for an audit for the 2015-2016 CPE reporting period. The respondent failed to respond to the audit after multiple communications were sent to the respondent. The respondent provided a response through a caretaker who explained the respondent has diabetes and is battling cancer. The respondent did provide 2 certificates of completion from the CPE store. My recommendation is authorize a formal hearing and assess a civil penalty of $1,000 and a requirement for completion of 16 penalty hours, and 2 of those must be state-specific ethics courses within 180 days.
Is this language about penalty hours sufficient in this recommendation, or we need to modify
Yes, sir.
it?
Yeah, that's what should have been included in the previous one.
Any other questions on 27?
Is this person practicing?
Their license is still in active status.
Assume someone suggested that they could go inactive. I mean, it just seems cruel a little bit. Diabetes and cancer to have a hearing. I'm just saying, I assume that.
The license is still in active status, but I'm happy to make a phone call and try to discuss the options.
Just a sad situation. Especially if there's a caretaker. I mean,
so this person did all the hours. They just didn't.
There was some, yes.
The only deficiency I believe was the state-specific ethics hours. Well, you have 16 penalty hours, so that must have been there were 2 violations, but it's not stated out.
Was it different?
it doesn't sound like there's a lot of sentiment that way, but I don't know. It just seems that if there ever were extenuating circumstances, this would be it.
Would it be possible to maybe give them an out that if they chose to go inactive, they would waive the penalty or something of that nature?
I would like that.
Am I speaking out of? Yeah.
Would be willing to support that in this case. I mean, it appears that the person has some grave medical issues.
The word caretaker suggests that it's not just an ongoing thing.
So, Pam, was that on motion?
I move that we keep this as is, but add the provision that if the person chooses to go inactive, that the penalty fines would be removed, or
waive them.
Or the civil penalty along with the penalty hours would be waived.
Motion, is there a second?
Second that.
Motion second. Any more discussion? All those in favor of the revised amended number 27, say aye. Aye. All those opposed? All right, 28.
2017027331. Complaint was filed against a respondent for providing unlicensed accounting service. This respondent was holding himself out as an accountant in the Spanish-speaking community where he was located and using the word contador on his website and on Facebook. Contador is a Spanish word for accountant and is very misleading in the Mexican community, and most individuals associate the term with a licensed accountant. The word contador is usually used with contador publico and translates to public accountant. The respondent did not provide a response. However, following an investigation, the investigator determined that this respondent holds a bachelor's degree in accounting and has 150 credit hours to sit for the CPA exam, but has decided to pursue his Juris Doctorate degree from Nashville School of Law. The respondent worked for a CPA in the Middle Tennessee area in addition to his own practice, but his businesses only provide income tax preparation services and bookkeeping services. The respondent also stated he has ceased using the word contador on any advertising since the middle of 2016. The investigator has found that the respondent's signage at his Knoxville office, West Knoxville office, and Sevierville offices still use the word contador on the signage. The respondent has removed the word contador from all Facebook page advertisements. My recommendation is to authorize a formal hearing and assess a civil penalty in the amount of $1,000 for using the title or designation of accountant without holding a valid CPA license in the state of Tennessee.
contador mean accountant and not bookkeeper?
According to what we have found, contador means accountant.
I've worked in South America, so I can vouch that it means accountant.
Part of this consent order, he would agree to remove his signage.
Does that need to be a motion to add to this?
Yes.
Does someone like to make that motion?
Well, I would have to include it in the consent order that he would have to remove that.
You need it in this report as opposed to us to say that or not? You do. So we need to make a motion to add that to the language.
Sorry.
Does someone have a motion they're willing to offer?
I move that we add removing
Sign.
the term accountant from the signage.
Motion, is there a second? Motion second. Further discussion? All those in favor say aye. Aye. All those opposed? All right, let's go 29.
29 is recommended for litigation monitoring. It's a rather complex matter. It's 2017000081. The complaint was filed by the then assistant controller of a multinational company. The complainant had began his employment with the firm in July of 2015 as the assistant controller, and alleged that the respondent did not use proper accounting/audit procedures for profit and loss statements. The complainant has stated that there was fraud committed by a licensed CPA over a 5-year period of 2012 to 2016, and the respondent also engaged in inaccurate financial statement preparation. The respondent provided a response and stated the complainant was a direct report to the respondent, and complainant had a personal animus towards the respondent. According to the respondent, the complainant did not want to report to the respondent because she was a female. The respondent stated the complainant engaged in discriminatory practices against women and created a hostile work environment at the company, resulting in the company taking action against the complainant. The respondent claims the accounting errors were originally uncovered prior to the employment of the complainant, and the senior management were aware of the issues. Also, respondent stated 3 full audits of financials were completed and no issues were found. An investigation was conducted by the board's investigator. The investigator concluded at present there was no conclusive evidence to support the allegations. However, in light of the seriousness of the allegations, this complaint should be kept open. The SEC is currently conducting an informal inquiry, and per conversations with the enforcement accountant and staff attorney assigned to the complaint, the respondent's actions are part of the review. Also, the respondent's former employer limited access to the board's investigator to persons with knowledge about the subject matter of the complaint. My recommendation is to authorize litigation monitoring/litigation hold in this matter.
Questions? 29.
I assume the accounting/audit procedures were quite serious.
Sherry, if you would speak to that, please.
They were in the dollar amount of $1 million in terms of a particular reserve at the company. There were allegations that the liability was not provided on the financial statements to meet specific results for that particular unit for bonus and performance purposes. So yeah, it's serious enough to where the SEC is looking at it
with intent in there. It sounds like.
well, there again nothing that can at this point be proven. One thing I'll add that's not in the narrative is yes, the respondent left the company in September of 15, but she was terminated. And the reason that she was terminated was she alleges that upper management was informed of this error or this inadequacy in the reserve amount, but she was fired for not informing senior management.
How did you get that information? I'm surprised somebody would tell you why they were fired.
I actually spoke with the one member that I was allowed to speak with at the company was the VP of internal audit, and he confirmed that with me. But he said also, as part of the internal audit, they had no definitive evidence that it was that error was, whether it was intentional or unintentional. And he did not provide me a sworn statement. That was part of the issues with the investigation. I had 5 employees that I wanted to speak to. I was limited to speaking to one who would not give me a sworn statement. I was also allowed to speak with the partner in charge of the external audit, which was a Big Four firm, and he would speak with me but would not provide me a sworn statement. So there was some limitations in terms of being able to do some of the due diligence that I would personally have liked to have done on this, but with an SEC investigation outstanding, it just seems appropriate to put it on hold at this point.
So the recommendation that legal is making is to put this on hold?
Sir.
I do have contact information.
Subject to the SEC's conclusion.
Sir.
Else? All right. Let's go to the representations on 30.
Sure. This one, 2017-050951. This is coming back to you at the request of the respondent. The respondent in this case did not provide CPE as part of an audit and was assessed 120 hours and $1,000 civil penalty. Respondent reached out to me to say that he doesn't utilize his license, that he's been employed in a capacity that doesn't require it for many years, and he wanted to, instead of paying the penalty and doing the hours, he wanted to agree to the voluntary revocation of his license instead. So I explained to him some of the implications of that, if he's licensed anywhere else, what the limitations would be as far as his practice. He said that he would think about it. If he changed his mind, he'd let me know, and he never reached out to me. So personally, I think while it's obviously it's an extreme solution, at the end of the day, it's recorded discipline for doing this, and we don't have to worry about this individual not complying in the future. They'd have to come before this board in order to be reinstated, as well as produce whatever hours would be required for reinstatement. So I thought, in my view, is if from legal, I didn't see a reason not to at least ask if he could do this, and I didn't think it was necessarily inappropriate.
Quick question. I'm not on this committee, but does that put a black mark on that national database where they can't?
Oh, well, yeah.
Okay.
Or not?
Well, even if it's still discipline, public, and it'll change
because
because
if he voluntarily revoke your license?
Anything that's a consent order is discipline.
Okay.
Anything.
Yeah.
Do you have any feel for how likely it is that this person may want to come back and practice again?
Yeah, he told me his only concern was maybe after retirement he may want to come back and do something like that. But he kind of mentioned taxes, so that's when we had a conversation about, it'd really be audit work that you'd be prohibited from doing, but you could continue to do tax work. And he said he would go think about it, talk to his wife, and let me know if he changed his mind, and he never did contact me. Now, it's potentially that I could reach out and say, okay, go ahead, you can take the revocation, and he may say, never mind. That's fine. In my opinion, that's fine. We can just have the old consent order, have them execute it. While it is unusual, it's not this is probably the 5th or 6th time I've had this request made since I've been here.
So I want to clarify the recommendation. The recommendation is if he decides to voluntarily revoke his license and then he chooses to reinstate at a later date, he would have to submit the 120 hours, but not the $1,000. Is that correct?
Yes. Sorry, I guess I hadn't thought that when I put there.
And we don't clarify whether the 120 hours, I guess, could be used for a renewal or not. So that's all.
Yeah, we could put the language that we've used previously to say that would be in addition to the reinstatement hours.
Anything else? Do we need to modify this, Wendy?
So the way it reads, the way I'm reading it right now is that we would settle with a consent order. He would voluntarily revocate his license. If he chooses to reinstate it at a future time, we would go back to this consent order, which would require him to submit the 120 hours that was initially assessed. But what's not clear is, will he then be able to use those for renewal, and does he need to pay the $1,000 or not? If he reinstates in the future, it would be a $250 reinstatement application fee.
My opinion would be that they would need to do this because we're letting him off because he's voluntarily revoking. If he comes back, I think what we're doing is just holding him in abeyance. We're not waiving them or anything.
Well, and also when they come back from a revoked license, they have to come before the board. So I want you all to be able to know whether he's met the terms or not that you would feel comfortable with to reinstate a revoked license.
But if that's the case, we don't really need to add anything here, right? Or do we?
Well, if there's nothing laid out in the consent order, we have nothing to go on.
Right. So
we just modify the consent order to say we're holding them in abeyance, and to the extent that you come back to be reinstated, then you have to satisfy them.
Correct. So I would make to this board, I would request a motion that would say, upon any request to reinstate the revoked license, respondent must submit the 120 hours of CPE and the $1,000 civil penalty. Those hours are penalty hours and may not be utilized for reinstatement. I think that would be the recommendation to encompass basically an abeyance and then also the inability to double dip, if you will, into those hours.
I would move that we add that language.
Motions or second?
Second.
Motion second. Any further discussion? Seeing none. All those in favor say aye.
Aye.
All those opposed? Okay. Last one, which I think should be 31, right?
Oh, yes. Sorry about that. 31. We added that later. This matter was previously in litigation monitoring, which is why it's a represent now. I won't lie, this case is complex. It was difficult for me to fully grasp, and so I was very thankful to have Sherry help me re-review this case, and so I may do some deference to her as we move forward. But just to set kind of the stage, this was an allegation from complainants, which are a married couple, who were previously, the husband of the married couple previously were in a venture with his parents, a farming venture, with each holding a 1/3 ownership of that venture. The allegation is...
Say mom, dad, son.
And son, that's correct. Wife filed the complaint, but is not a partner in the business, I believe. Nothing that we have said that, so yeah. Ultimately, there was a falling out over the years between the parents and the son, and the parents created a new LLC and moved all the assets from their joint venture to their own LLC, parents alone, leaving son out. And the allegation was that the CPA was complicit and in fact instructed and assisted in committing fraud against this 1/3 owner. The CPA respondent represented for many years all of these parties in their business as well as their personal tax returns. And had previously said there wouldn't be a conflict. So from that, the complainant made a number of allegations, including using confidential information, exchanging confidential information between the parties, really all of it to the benefit of the parents, subjugating judgment to the parents as far as how things are reported, what income is reported, not following through with due professional care to verify different numbers, and really just ultimately, and I'll let Sherry speak to it more, I think the major issue here is it does seem, after going through 3 investigations and an expert report, which I will say is from the complainant's hired expert witness in the civil case, that this individual really just did whatever the parents asked without much consideration for the son. The leaking of information, there are some allegations that they allege that we don't have evidence of, such as what client information was exchanged, just because ultimately it's going to be what they said, what she said, back and forth. But as far as the civil case goes, it was settled, so I don't have a court order really spelling this out. But what we do have, all I could get was, my understanding is, as part of the settlement, the complainants were not to participate in our board action as part of their settlement agreement. However, I have informed them that I will subpoena them anyway, and they are understanding that they will have to abide by the subpoena and are fine with that. I don't know what the terms of the settlement were because it is not available to me. It's confidential. However, it was indicated to me that it was favorable to the complainants,
or at least they found themselves satisfied by the settlement in a way where they felt that the allegations were worthy of consideration. So with that said, I'm going to let Sherry, if she's comfortable, talk about a little more of the nuances of the actual technical violations, because it does involve tax returns and partnerships, and things are difficult.
I was going to say, of course, I didn't do the investigation, but what I'm going to attempt to do is to bring out the points that Don brought out. And there was an initial investigation report, a supplemental investigation report, and I also did review the valuation report from the external CPA as well. Okay, so I'm going to try to go through these as quickly as possible. There was the issue with Rule 0020-03.10 regarding client confidentiality. Based on reviewing those reports, while there might be a strong possibility that a breach occurred, he did not find any hard evidence of that, and those are always hard to prove. In regards to Rule 0020-03.04 related to integrity and objectivity, again, subordinated judgment to the client, Don pointed out in his report that there was a tax treatment of a hedge account with Prudential, that basically the tax treatment was dictated by the client rather than ownership of the account. The account was owned solely by the father in the family trio. Yet in some years they reported the gains and loss on the partnership return, and sometimes they reported the gains and loss on the individual, the father's and mother's 1040. There was also a $293,000 partner cash distribution on the 2009 partnership return. There's no documentation for that other than the notation that the father said they made this cash distribution. It drove the partner's capital balance negative at that point. And the partner, which is the complainant, said a cash distribution had not been received. And again, there was no evidence. And based on the report, Don went to the respondent's firm and reviewed the tax work papers. Okay, so he saw no evidence in the tax work papers to support that distribution. There was, the respondent included a gain on a cattle sale on the complainant's 2013 1040, which belonged on the partnership return. Again, no evidence even of the transaction based on Don's review of the tax files. Rule 0020-03.07B related to competence and due professional care. In the report, and basically this was in the report but confirmed with the correspondence in terms of the response of the respondent, that he forced the capital balances to balance the Schedule L on the partnership return. The forensics report from the outside CPA confirms this because they state that there's gross misstatement in the partner's accounts throughout all the tax periods. Don interviewed the complainant's current CPA, who also served as an expert witness in the trial, and that current CPA pointed to multiple errors in the tax returns prepared by the respondent, both the individual, partnership, and corporate returns. Basically, he did the individual return, the partnership return that included all three family members, and then there was an S corporation, which was owned solely by the son. Okay, so that's what I mean by the corporate return. Rule 0020-03.07D, competence related to sufficient relevant evidence. Don noted in his review of the tax files that there were no copies of the articles of incorporation, corporate minutes, any partnership agreements, or any partnership dissolution documents in any of the respondents' files. They had none of that information. Tax returns were prepared from check registers from Quicken. No balance sheets for the businesses were obtained, and there was no documentation to support any of the assets, liability amounts on the Schedule L. There was no documentation for the removal of mortgage loans or asset sales on the complainant's corporate tax return. On the 2013 return, there were some sales indicated on that return. The complainant claims those sales did not occur, and there was no evidence of it in the tax file. Rule 0020-03.08 related to compliance of standards. Some points that Don brought out was that the 2013 corporate tax returns that I've mentioned had some potential errors on them. They were e-filed without a signed Form 8879. I'm sorry if I'm going.
I'm curious where we're going. What are we doing with this?
I don't know. I have it as discussion. There is a number of, we have quite a.
Because all we're doing right now is hearing all the allegations, right?
Yes, I mean that's what the legal report is all
I mean,
about.
are you asking to reopen the investigation?
I'm asking for. Oh, I'm sorry. I'm asking for the discipline. There's never been a discipline associated with this because it was in litigation monitoring, meaning we just put it on a shelf to wait for the litigation to go through. Normally, what would happen is we would get something from the litigation that I could give to you. They settled it confidentially.
We talked to the respondent.
Oh yes, three times, if not more. Don has had multiple. There's pages and pages of respondent responding, providing us what he has. Every party has been fully engaged in this process.
Does the respondent deny these claims?
Yes, the respondent denies the claims. Yes.
Okay.
I mean,
I think we're back where we were earlier.
The report does provide the report. What I'm trying to, I guess, delineate here are the things that Don saw with his own eyes in terms of reviewing.
And I'll just throw this out there, and y'all correct me if I'm wrong, because I am an auditor and not a tax guy. But I know it was our firm. We will keep certain tax documentation, but sometimes we will return that to the client and not keep it. So I don't know if there's any rule that requires us to maintain backup for the filing of a tax return. Am I wrong in that regard?
Well, the standards for documentation of an audit file are completely different from the standards for documentation of a tax return file.
My point being is that as you say, hey, they didn't have evidence, I'm not sure they're required to maintain that evidence.
This is a question for me. What about like permanent file type situations for tax returns? Like,
I don't know that I'm required to keep any tax documentation. Period. I mean, I don't think that's true. You might want to go back and check that with IRS records, but
I think it's the. I don't know. I mean, I'm just telling you what I think. I think it's typically the client. It's their ultimate responsibility to have the documentation to support.
I guess for best practices, or maybe that's the problem here is we're looking at best practices, but in my experience, we retain copies.
Here's where we're missing the boat, guys. And I've got one. I'm going to go back to number 15 on this because we're making a lot of assumptions here, and it's starting to worry me as to what's in this report. And I feel like we're jumping out on some ledges here, and I'm not sure you could prove this with our administrative law judge here because you don't have the full picture.
Mr. Watkins, when we bring something on a legal report, the standard that we are meeting is probable cause. If we find that there's a determination based on the evidence that probable cause exists, we will put it down for a settlement. They can say no to that settlement and have a hearing.
Come in and respond.
And they can come in and have a hearing. And
but I'm getting really concerned when I hear, like, I've got a respondent that says he didn't do anything.
Correct. And he lost.
And I got to claim it. Well, you don't know what happened in the settlement. You just said that, right?
It was favorable to the complainants, but I don't know the terms.
Well, I mean, okay.
Let me ask a basic question here. Who filed the complaint? Did the parents and the son, were they all three file the complaint, or did the son file the complaint?
That's right. Against
the so this sounds like a family squabble. I mean, we could investigate this for the next 3 years and maybe not chase down all these loose ends that we're talking about.
Right.
So it could be a big black hole we're falling into here.
Absolutely.
But as a result of the court settlement, if the family situation or disagreement got settled, will they agree? Will the son or whoever filed the original complaint agree to withdraw that complaint?
Claimants have.
No.
Haven't they?
No. That is why I'm here, because I contacted them and said, you have a settlement. What is it that you anticipate happened? They said, we believe misconduct that is related to his license still occurred. That's worthy of investigation. I met with the assistant commissioner about this case and presented the facts that we had in the investigations, and he concluded that the board at least should consider the fact that it seems that misconduct related to him as a professional could have occurred, or that we had probable cause to believe that they did through two Don Mills investigations, all the documents attached, a forensic accountant report, and ultimately whatever documents I'm hoping to get from the litigating attorneys. That's been a battle.
So the son still wants to pursue the original complaint.
Yes. As much as they know that they're not technically supposed to under their settlement, but I've been told that I can subpoena them.
As part of that,
And you've told the son that, so the son.
I told them that, are you comfortable with the fact that because of your settlement agreement and you can't come willingly, that I'm going to be subpoenaing you, and they agreed to be subpoenaed. Not that they had the choice, but they know that that's.
But you said he signed an agreement as part of that settlement not to pursue the complaint.
They said that they wouldn't speak to the allegations, which obviously hampers me. Now that settlement, they have no control over what I do. They are victims in a case.
I understand.
So we independently met on this with our assistant commissioner and thought that the evidence was sufficient, at least to bring to y'all. If you think it's a family squabble and want to close it, that's actually something we had discussed. That's why I have it as discussion.
I don't even know how we would make a determination of a penalty at this point with what we have.
I agree. I mean, obviously, I was trying to draft this up, and it was such a mess that I had engaged Sherry only a week ago, and she has not been able to do any independent work. It's entirely reviewing what I had from Dawn and from the independent CPAs that have looked at this. And so I agree that this is a very messy case. And my original gut was that we should just let it go. However, because of the substantial allegations of, inventing hundreds of thousands of dollars in the files, it seemed at least worthy to bring to you. But I think that your concerns are good, especially Chairman Stewart, too, as far as it may be hard to figure out the truth because of who's supposed to own the information, where the information is, and how much of it is now barred by the court.
Would it be appropriate to ask the son to file a new complaint with specific, or maybe you don't need, we don't have the original allegations here. We just say they were numerous, but to see what exactly the allegations were. And
I have the list. They did make a list for us. It's breach of client confidentiality, due professional care, subordination of judgment. I have the whole list. We made a list: dishonesty, fraud, and gross negligence, compliance with standards, and insufficient relevant data to support. So they did do.
Well, half the stuff that we talked about, you didn't have any evidence one way or another, right?
No, the only thing we didn't have solid evidence of is client confidentiality.
They kept saying they looked for records and they could not find records.
Well, right, but I think the thing that the absence of evidence here is where we have the concern, because we have all of these tax documents that say different transactions occurred. We have a forensic accountant and a family saying we never got that money. We're fine to walk away from the partnership, but we're still owed $329,000 in disbursements before we're at net zero for dissolution, and we never got it. And then we got Dad and his CPA and Mom saying, yeah, we gave it to you. Look at our tax documents. But you're right. The problem is coming. Everyone, they're going to continue to say we never got it. They're going to continue to say yes,
squabble.
You did.
Yeah.
And then it's going to have to be like hardcore discovery, hiring of experts, thorough litigation to get there. But at this point, just based on my obvious need to rely on my expert, and then a second expert confirming it using paperwork, I believed it reached the bar of probable cause to at least bring to this board.
But some of this seems like a legal dispute, and
it was, and it's settled now, yeah.
But we don't have how it was settled.
No, unfortunately not. And that's why at first I was like, well, I'm not interested. If you were willing to waive away your right to participate in this complaint, you obviously weren't so invested in the merits. However, there's, you're talking about a family
and you
trying to
got
run a
burned
business.
bridges and you got animosity.
How much money they're shelling out for an attorney.
Have we had a situation where something came out of litigation monitoring and we were able to actually pursue it when there's a settlement?
Most of the time they settle with us. Because at the end of the day, if I've got a court order saying they did something, they're not going to try to take it to a formal hearing. A lot of the times, exactly what you're saying, Trey, happens, and they settle, and we close the complaint based on the fact that the parties, in theory, are resolved. That's not always the case. We had, I can say the name now because it's public record, we had Charlotte Abercrombie, where we had a case where she paid out a large settlement, had a judgment against her for defrauding folks through tax, and we still came back and revoked her license. Now, we didn't do an informal hearing. She ultimately agreed to the revocation. So we have had it where it comes out of litigation, and we have moved on the license based on the underlying misconduct.
I want to make a suggestion here, and those transactions you're talking about are among related parties. I mean, they're among families, not just related parties, and father, son, and I think it'd be hard to pin down anything with regard to those things. I'm going to suggest that we dismiss this case or close it. And as part of that, we can go back to the son and ask him to, if he wishes to open a new complaint based on the fact that the court case has been settled. If he wants to give us some specific allegations, then we will reopen an investigation as a new complaint.
I don't believe under his settlement agreement he probably won't be able to do that. But I mean, I guess that's the choice that he made.
But we'll throw it back into his court.
Yeah.
I really think he may be, just using us as kind of the strong arm of the law to create some.
He is, because he waived his right to be able to go against. So
I think it would
unless
be
we
different
pursue
if we
this
had,
one,
I mean, obviously, if
it's
we had very specific, concrete information that a violation had occurred, we would not dismiss. But we have not determined that.
I mean, and it's exactly the things that you're talking about that probably are the reason the litigation settled.
Yeah.
It's just ambiguous enough where no one wanted to try it.
Yeah.
Yeah.
I also wonder if we don't get ourselves sideways in court where we open ourselves up to argument that we don't have the authority to pursue it because it arose out of a claim that was settled by somebody else.
We've actually had that issue arise. And
when we know of a violation, but right now all we have are allegations by somebody who's settled, right?
Well, no, I guess it's kind of knowing is a hard. That's not really the standard, right? Like ultimately, if I can prove by a preponderance in a hearing that a violation occurred, I can take something all the way to that hearing. I'm not precluded by the court and their individual action because the complainant cannot bind this board in a settlement agreement that it didn't agree to. We're not a party to their settlement. They can't speak on behalf of the board and say what we do. Complainants bring us the action, but they are not a party. And so what they do in their own case doesn't have any bearing on this, just like settling a civil assault case wouldn't necessarily waive your criminal assault case.
Right, I mean, practically speaking, though, they're not going to be able to talk to us about it.
I can subpoena them despite it, which is what I intend to do. We've done it in other cases.
And you're going to end up in court, probably. That's what I'm saying. And I mean, the point is, we have limited resources.
At the end of the day, you're right. They'll try to squash the subpoena, and it'll be a big headache. You're dead on right.
But can we move forward with what Casey was suggesting?
Absolutely. And that was something that we had tossed around. Wanted to make sure y'all saw this one.
I move that.
One clarifying question. Do we know if the respondent has any disciplinary record?
Should be here on there. None. So this yes, and I looked at that before because I was curious. He emailed me the other day to ask about this complaint, but he has nothing on his record.
So all those in favor of closing number 31, say aye.
Aye.
All those opposed? All right, we've all the ones we amended. I'm sorry, Trey, you want to go back to one?
I want to ask a very specific question about 15 because we got into this whole fraud and everything else here too. We basically said that the respondent did not put deductions on a return knowing the intent, and we have that respondent confirm that.
Absolutely. It's in an email, and he confirmed it.
He confirmed that he intentionally withheld deductions to meet a loan value.
Yes, we have
whatever.
written evidence of that.
Okay.
So the problem there is not that he under or over reported taxable income, but that his balance sheet his net equity or whatever net worth was distorted.
Are we back at number 15 or number 31? Back to number 15. The problem is, I mean, I think somebody mentioned it before, you can choose not to take deductions.
Yeah.
I think the problem is this tax return was knowingly being used by a third party, and the respondent was well aware that it was being used for that purpose, as well as the regulatory filing with the IRS.
But it never went to the third party.
It never did go, according to but the intent was for it to go there.
Do we know why it never did go?
Well, what the complainant told me was she found another more liberal, or more, that's not a bad word, but she found another lender that had more easy requirements for her to jump through.
So do we know why the respondent said it never did go anywhere? Do we know why the respondent said it never went anywhere?
The respondent didn't know whether it went anywhere other than the IRS or not. He knew that it was going to, okay? I mean, it's clear in the... This is one of those things where it'd be nice for y'all to have a copy of the email. And that's why I say I don't think that he considered it a problem.
Yeah, you said that he didn't think there was anything wrong with it, right?
He didn't. He acted as if, again, when he brought that up, it was like, I asked some questions about some allegations that the complainant made, and said, well, she told me to do it, and here's the proof.
So, at the interest of getting shot here for taking the time, do we have a standard that we follow for our investigations? The consistency, in other words, it seems like on some of these investigations, we've talked to both sides of the ledger as far as verifying that something was true or something that was not true. What did the respondent say? Do we have I'm not looking for an audit program, but do we have some standards of here's what we always do, here's what we never do? It seems like to me that for your protection and ours, that we should follow a consistent pattern. In other words, always ask the respondent what he thinks or not. Always follow up with evidence of any accusations that have been made. It seems like there should be some consistent procedure, just like we have standards to follow. An audit, you should have standards to follow in your exams.
Mm-hmm. I would agree, and I would like to make just one comment going back. I'm
not critical. Don't take that as critical of you.
No, I'm not.
I think I'm trying to help you.
Yes.
Because
I give a little background on when I first got here, we were never going to the to the respondent. I'm sorry, to the complainant. We were never going to the complainant. And we talked about the process and that you should be going to the complainant to confirm the allegations, get specifics on the allegations so that when you talk to the respondent, you know exactly the issue. And I think as part of that evaluation of the process, we also incorporated some more specific RFIs, request for investigation. So when legal asks for an investigation, they have 1, 2, 3 page requests for investigation where they ask Sherry to do very specific things. Contact the complainant, get this. Contact the respondent, get this. Ask questions about this. I think the one instance that I see as an issue here is the one I don't have
23.
Number 23.
Number 23
is where the allegations were all checked out, and then she found some additional information, and maybe the problem was not going back, obviously, to check on those with the respondent.
I think maybe, and I'll let Shalina speak to this too, there was a little bit of concern on number 23 in terms of the fact that we were talking to a former client that the client did not file the complaint. Her current accountant filed the complaint, and there may have been some concern there. That's why I was trying to say in terms of legal issues that there may be some concern there. She agreed to cooperate, but she was not the complainant herself. And I don't know if Shalina can talk to that or not.
That's correct. The complainant took on these new clients, and this was one of those clients.
Just to take my question one step further, and then I'll hush. Does the investigator position report to legal, or do they report to you, Wendy? When there's
I have a dotted line to both, to be honest. I mean, the statute says they report to you all.
Administratively.
But administratively, I'm the one that handles her performance evaluation.
I'm not getting there. I'm
Okay.
saying if there's if she's in the field and a question comes up, should I talk to this person, or should I take this any further, or should I back off? Who does she call?
Talk to Shalina and typically copy me on her questions because those types of questions are generally Shalina's the one who needs to answer. Just kind of keep me informed.
I think that's a good point. And let's finish the report first, and we'll get to that. That's okay. We've amended and approved already numbers 12, 15, 23, 26, 27, 28, and 31. We need to approve as recommended the remainder. So we'll do them in chronological order. So is there a motion to approve as recommended numbers 1 through 11?
Moved.
Is there a second?
Second.
We have a first and a second. A motion and a second. Is there any other discussion? Seeing none, all those in favor signify by saying aye. Aye. All those opposed? All right. Number 13 and 14 next. We have a motion to approve those as recommended.
So moved.
We have motions or second.
Second.
Any other discussion? All those in favor of approving as recommended number 13 and 14 say aye. Aye. All those opposed? All right. Is there a motion to do 16 through 22 as recommended by legal counsel?
So moved.
There's a motion. Is there a second?
Second.
Motion second. Further discussion. All those in favor say aye.
Aye.
Aye. All those opposed? All right. Is there a motion for 24 and 25 to be approved as recommended?
So moved.
And when you're saying as recommended, you mean with the additional comments that were made, right?
These are all that we didn't change. We did all the amended ones we changed and voted on during the process, and all the remaining ones we
voted on those as we went.
24 and 25. We have motions or second? Motion is second. Any other discussion? All those in favor say aye. Aye. And then 29 and 30, is there a motion to proceed as recommended by legal counsel on those?
That's a quick question on 29.
Sure.
In the last paragraph there, where it says on page 25, it says the possible violations. This is one that we're saying we're going to put on the shelf.
Yes, sir.
Should possible say alleged instead of possible?
Sure. I can amend that to say alleged.
I'm not a lawyer. I'm just saying at this
Well,
point
I mean,
we
these
don't
are
know.
possible violations. I mean, it's very similar. I could
Gabe, how do
say
you feel about that?
Okay,
possible.
I'll defer to you.
I'll change it to the alleged.
Should I vote on that or not?
If it requires us to revote and possible is fine, let's leave it alone.
Okay. So I'll accept a motion on 29 and 30 to approve as recommended. The motions are second. Any discussion? All in favor say aye. Aye. All right. All opposed. And then I think a good takeaway is I think we probably need to get legal to work on this idea of what a standard operating protocol is for investigation. I don't think we're looking for a blue book version of this, but even if it's a one page or about here are the things like a checklist of what you at least need to do, I think that would be helpful for you, Sherry. And I don't know that there's necessarily a time limit on it, other than the fact that if I were in your position, I'd want that as soon as possible.
I would agree.
All right. All right. That concludes, after 3 hours, the enforcement committee. So much for that.
I ask if everybody would like to take a 5-minute break before. We're going to be here late at this point, so would you like to take a 5-10 minute break?
Thank you.
If not, I'm going to leave anyway. But
We're going to take one.
Take one. Talking with Wendy, we're not going to have a quorum here for the executive committee to meet today, so all of the agenda items under executive committee we will just cover as a full board tomorrow, and that hopefully will not be any problem. I've looked at all the information Wendy sent out, and most of it's pretty factual and understandable, and it should go very quickly. So what we're going to try to do is get through laws and rules as efficiently as we can, but there are some important things over.
I am just stepping in. You realize that I'm not the actual chair of this, right? Don't hold me to anything.
Yeah. Gabe Moon is obviously not with us today, and I think Trey knew that, and so he agreed to serve as chairman of that committee today, and today only, the hardest day.
Does she come? Is she going to be here tomorrow?
No.
Oh, she's
Yeah.
on a fabulous vacation on a riverboat in
Czech Republic.
overseas somewhere.
Gotcha. Yeah, Viking. All right, so the first thing we had up was the CP rules, and I guess with the Attorney General's red lines on it. Do y'all want to talk about that?
Help me with this, but I'll try to start off here. So these are rules that you all had previously approved, and once you approve them, they go over to the Attorney General's office for their review. In this particular circumstance, they sent them back with a significant number of red lines, and legal counsel felt like with a number of changes that you all should look at it again. I have reviewed them, and really the most significant change that I felt like probably needed to be reviewed by you all was on page 3, number 9, where we talk about, this is where we talk about the ability to submit 16 hours of CPE from a non-registered sponsor for approval. And so the change here basically is in the first sentence, to receive any program of continuing education not specifically covered by this rule must be approved by the board. What you originally approved was submitted to the board. So submitted to the board and approved by the board are two different things, meaning, and this is prior to attendance or completion of the course. So those 16 hours, if I want to take an 8-hour course, it's a CLE course, they're not a NASBA sponsor, then I can submit it to the board for approval. The point of the rule change was that they have to do that in advance of attending. And so what we approved, it had to be submitted in advance of attending. But we've changed it to approved, which was my intent all along, was to be approved. Now, policy allows staff to approve these. They don't actually come to the board meeting unless we were uncomfortable for some reason with what was being submitted.
This change, though, is in accordance with what you were really anticipating anyways.
Right. And I think it's a good suggested change. Right. The last sentence, also, a licensee will not receive credit for attending, completing a program that was not timely approved by the board in accordance with Rule 0020-05-.09 is actually an incorrect reference. And so, or that's what I sent you in the materials. I think it's updated on your iPads. Right. So it should be this section, paragraph 9. So they just didn't quite do that right. So I think what's on your iPad is what you would, is correct. And I may let Liz address any of the other red lines that she thinks are notable. I just went through the number 9 that I thought was the most important on the CPE rules.
Okay. Really, the other red lines on the actual rule portion are just pointing out the different statutory references that either are no longer relevant to the authority of the rule or adding in one that is. Also, as far as new changes, Wendy really only addressed the only new change in Rule .049. The other red lines that you'll see further in the packet are the AG's suggestions as far as our explanation to the governor's office as to what these rules do, how they do it, and how they'll affect small businesses and consumers. So the changes that you see reflected in the answers to the regulatory flexibility addendum are more of a cleanup of our previous explanation. They essentially say the same thing, just a little bit cleaner, and they're aimed at receiving less questions from the governor's office so that this rule can move forward smoothly in the process. But if you'll take a glance at those, because some of them do have a lot of red marks on them, and you did previously vote to the answers to the questions that were in the original draft. So we just want to make sure that you're okay with the answers that the AG suggested.
Do we need a motion to approve the changes as recommended?
Yes.
Okay.
This is an informational item. How frequently do you get submitted requests under this kind of 16-hour, non-NASBA or non-pre-approved rule?
Well, we used to rarely get it because it was in policy. It wasn't as clear to licensees that you could do that. And then it became rule maybe a year ago, and so we've received a lot more since then. I would say, but when I say a lot more, it's still not a ton, maybe 5 a month.
Part of the reason for that increase is our department in the past few years has implemented electronic notifies for licensees to update licensees on rule changes. The department really wants to make sure that licensees are aware of everything, even a small rule change detail that could affect them maintaining their license. So the last time this rule was changed, all of the licensees were notified by email, and that's probably why the increase came to Wendy. So the same thing will happen when this rule is changed here. Another electronic notify will go out to licensees to update them of the potential change.
Thank you.
Any other questions? Okay.
I'm sorry, if we could do a roll call vote to approve the changes on this red line.
Okay. You go ahead and do the roll.
We would need a motion first. I was just reminding you it
Oh,
needed to be a roll call. I'm
we
sorry.
don't have a motion, do we? Anybody want to make a motion to approve the rules? Do we need to specify that this has been updated with the reference number, the 0409?
I think the one on
Because
your
that's
iPad,
not
the one,
okay.
one on your
so
iPad
this is fine as is.
Correct.
Okay.
Right. And so if you want to reference the document on the iPad as being correct.
Okay. All right. Who would like to make a motion?
I'll move that we approve the red line version of the rules as revised here, based on the iPad document that we have.
Second.
Okay, we have a motion. A second. Is he on the committee? Sorry. Okay, we can't do that. Thanks. That was a good try.
Second.
Who made the motion?
I did.
Kevin.
Oh, Kevin. Okay, he is on the committee.
Yeah, he's on Eddie and Janet.
Oh, and I apologize while we're amending. This would be a motion to recommend to the full board that the full board adopts the red line changes on this rule, so that we'll actually do the official board vote tomorrow.
Understood. I respectfully would submit my motion that way.
I'll respectfully withdraw my second.
I will second.
Oh, okay, Janet. Go.
Any discussion? I hope no more. All right. You start the roll call for us?
Janet Booker Davis.
Aye.
Kevin Monroe.
Aye.
Trey Watkins.
Aye.
Judy Weatherby.
Aye.
Okay. Here. You also have a fictitious names rule in your on your iPad. And I actually read through that. I'd be curious if anybody else read through it, if they had any commentary on it. I don't know who had a chance to look at it and who didn't.
Trey, I'm not a member of your committee, but I have read through it multiple times and read through our old language and the language that's been presented here, and I think this is 1,000% improvement over what we had. I mean, I don't think anywhere in here in this new proposed language uses the word fictitious. And this is pretty much patterned right after the model wording in the Model Accounting Act, or whatever. And I think it's good. I think it accomplishes everything we talked about at our previous meetings. And this has just really been, I think, a huge source of confusion for the board. I mean, I've sat in meetings in here that some of you were in, but where we had one board member, at least one, that felt like you couldn't have a firm name at all unless it consisted of the names of the individuals in the firm. And that's clearly not what we've been doing for a long time. And I think this totally addresses that. I think it gets rid of the confusion by a word like fictitious. I just
and it leaves some flexibility, I feel like, too, for the board
Yeah.
to act in a way they feel necessary. Yeah, I agree.
I'll
Gabe, did you have a
hush,
chance to
but
look at this?
I'm very much in
Do you have any
favor
issues?
of, the
You like it?
language that's been presented
Casey,
here.
did you have a chance to look at number 4, where I mark through ambiguous names and I kind of try to say that in a different way?
I did, and I think that's a great improvement there.
Okay,
I mean,
okay.
I think that's good.
Okay, well, I'll entertain a motion to approve at tomorrow's board meeting the document as revised.
I'll make that motion that we approve the document as revised for the firm names.
Didn't you want a second?
Second.
Any discussion? Do you want to do roll call again on this?
Sure.
Liz? Okay.
Janet Booker Davis,
Aye.
Kevin Monroe,
Aye.
Trey Watkins,
Aye.
Judy Weatherby.
Now, just a question, we're going to approve this document, but this still has to go through the rulemaking.
Yeah, so what you're going to
Right.
see at the next meeting is you're going to see this on that nice official form,
Okay.
and she's going to have to read all that stuff in the record and the flexibility addendum.
So we're a long way from being
Yeah.
finished administratively.
Yeah,
with it.
I didn't put it on there because I thought there might be more discussion, and so we didn't go that far, but we'll bring that to the next meeting.
That way, yeah, at the next meeting, it'll be clean on the rulemaking form, approved as edited multiple times, and it'll be a little bit quicker of a process. It does reserve any last chance editing that the board might want to make or might discuss tomorrow at the board meeting.
Okay, and the last issue here is the nano learning and blended learning. I know we've had conversations about this.
Okay,
We're
yeah,
having a presentation tomorrow.
there were no documents for this, but I'm
Yeah.
just going to give you a heads up on what's going to happen tomorrow. So Jessica came to our last meeting from NASBA. She's the director of the CPE registry. And she is coming tomorrow to do a demo of a nano learning course. We have been back and forth about whether nano learning is allowed in the state of Tennessee. And we kind of had a recent situation where we reviewed that higher up in legal, and they do feel like we can get away with allowing it. However, strongly advise that we create some new wording that makes it a little clearer. So after you all see this tomorrow, I would basically like to get your okay that yes, you would like to see this happening and allowed in Tennessee, and then maybe we'll go back and work on some wording that would make it clear.
Right now, under our current rules, nano learning would be acceptable, but there's not quite a rule that specifically addresses that, so it would clean it up a bit if we added a rule that specifically addresses the nano learning, if the board would like to allow.
Okay. Mr. Chairman, that ends the Law and Rules Committee.
Okay, we will adjourn the meeting and meet as a full.
It's 8:30, right, tomorrow?
Yes.